830. My lord, I seek your lordship indulgence in allowing us to call for, my lord, two interlocutory applications we have filed in item number 12. In item number 12, the two IAs have not been posted. We have filed long time back. Kindly let me call. I'm obliged.
May it please your lordship. My lord, item number 13 has been fixed for hearing. In this case, earlier occasion case was dismissed for default, and the LCR was sent back, my lord. That has not been received. So, my lord, the LCR be called for and fix a date for hearing, my lord.
You are for
I am for appellant, my lord.
I'm for the
item
respondent.
number
Item number 13, 13.
RFA.
RFA, my lord.
Your name is not there.
No, my lord, actually, I have appeared in the IS earlier occasion when the matter was dismissed for default, and in the RS the name has not been reflected, my lord. That was the problem.
Okay. Mr. Sahul, Lord, you inform the other side.
I'm for the
Please,
respondent.
Okay. Concept the other side. Let's put the matter after.
My lord,
16th of September, Lordship. 16th of September. Lordship.
Okay.
by the time LCR be called for.
Let's just reminder the Lord, trial court for transmitting the debt.
Obliged, my lord. And my name may be so reflected.
Decision also reflect the name of the Sahul. Appellant.
Yes, I'm for listing a case on.
Go to court number 8. Senior court.
Court number 8. To be the content of the address, I would like to mention item number 11 also.
11.
Only method of the agent book
Mr.
S. Bulwa.
S.
Bulwa.
Learned counsel appearing on behalf of
Respondent.
your name is not there. You are appearing for
K. Sharma. His name is also not reflected.
S. Sharma.
K. Sharma.
You inform the other side.
Yes, that I appear.
Okay. Any objection? Any objection?
No, ma'am.
That the press for the
Okay.
May it please, your lordship. With the consent of the other side, I beg to mention item number 8, your lordship.
item number
8.
8.
Matter may be passed over for the day, lordship. Petitioner's advocate's mother is in ICU, lordship, so she won't be able to come and conduct the
You
hearing.
are appearing for
On behalf of S. Sharma,
Eh?
Miss S. Sharma.
your name.
New Surgery, lordship.
You you inform the other side.
Elevated, but there are other responsibilities.
I have informed.
Inform.
Yes,
What are they?
yes, lord.
Okay.
Obliged, lord.
Hello. This case has been filed under wrong provision of law, my lord. It has been filed under wrong provision of law. That is why I am willing to withdraw it with the liberty to file a fresh.
Formal order appellant arrested and depart
Right.
how about departure?
May it please, your lord. This is second bail application under NDPS Act. Your lordship's earlier order is at page
Earlier order is at page number
43, my lord.
40.
The lordship rejected that on the ground that it was a commercial quantity.
Now, what is the ground?
Ground, my lord, reason was not furnished under section 50 CRPC. My lord, I have annexed the notice, my lord, for page 48 and 50. On this ground, my lord, other two accused, accused number 4 and 5 has been released by your lordship. I have annexed a copy of the order. 48 and 50, my lord, two accused.
Third case, petitioner of the accused and does for the court death for setting and of setting for taken and the case is for 38 of the four. Right out of backup for other certificate for one certificate married 5 per day or deferred by the and the earlier availability and the PN number it would be 5 4 5 4 third day further second for the doubt of the arrest of the accused at the time effecting their arrest by the and the officer here and so the present of of the of state or by order to edit it's the get copy of the record of married
Of, on 22nd August. Published.
That will come after 4 weeks.
after
After 4 weeks.
4 weeks.
Yes.
Why?
My lord, still waiting some instruction from the client.
The detect
Yes.
learning for the petitioner right for the matter after 4 weeks.
4 weeks.
Where
Lordship, the conducting counsel, Mr. J. Borua, is unwell. Lordship may kindly give us some time.
My lord, in this case, in fact, stay was not granted and the trial court is proceeding with.
or that
That's not that.
part of
P. Shaha, on behalf of J. Borua.
third
J. Borua.
step that they would want it after 1 week
27th August.
7
August. Deeply obliged.
Obliged, my lord.
Hey, when was take instruction melody? Not the 2 days time maybe given because in the last week I have gone medical leave, so could not able to take the inspection.
I have one small difficulty, my lord. On 21st is fixed before the learned trial court, and the understanding why it is fixed today, that short notice is that for the instruction.
When
As the motion states, before the trial court on 21st, Lord, let it be stayed at least till the returnable date,
before that day,
or before that date.
or uh, of the left of the correct, uh, place that of of- of 20.
20th.
Okay.
Good.
May I please, your lordship? In this matter, lordship, we need some time to file a rejoinder to the
File?
rejoinder. Lordship.
File?
A rejoinder.
My
A
lord.
reply affidavit.
As per, as per your,
petition.
my lord, as per your lordship's order dated 4/8, my lord, I have filed my affidavit in opposition, my lord.
They have
Uh,
filed yesterday, lordship. So we can
No, my lord, on 8th, we have filed. Whatever, my lord, that is not on record, my lord. So let that objection be on record also, my lord. The objection I have filed, my lord, as per your lordship order dated 4/8, my lord. I have filed on 8/8, my lord.
lordship, we have received this.
But the provision for filing is
Rejoinder, my lord.
yes,
My lord.
not only rejoinder but
My lord, your lordship has directed me to file after hearing both the parties, my lord. That's why I have filed this objection. Otherwise, I have not filed this.
why it was directed?
My lord, they are seeking, my lord, injunction, my lord. They are praying for injunction, and I was only saying that, my lord, both the parties may be directed to maintain status quo, my lord. That's what, my lord.
Or it? By on when
On
by
8/8/2018, my lord.
8
8, my lord. Good evening, 8.
get on
They will be filing, my lord. Short date, my lord. Much obliged.
You oblige.
My lord, only one thing, my lord. That withdrawal item, my lord. That withdrawal item 20, my lord. One thing, I may be allowed to take back the certified copy, my lord, so that I can.
expect
Second appeal, my lord.
The?
Of this appeal, second appeal, RSA. Item 20, my lord.
that the certified copy of what?
Of the impinged judgment.
Of the
Much.
May it please the Lord. My lord, the notice has been issued for substitution of respondent number 16 on condonation petition. That has not been returned. So we have to wait for service report. My lord. My lord, in this case, my lord, he was the pro forma defendant. Though initially we have not objected, my lord, he was all along ex parte in the trial court as well as appellate court. And now also, I have gone through the record that to the respondent number 16, notice was served. AD card has returned at that point of time. Now to delaying the process, my lord, kindly see the IA which has been filed. Defective IA has been placed before the court, my lord. Defective IA. Now I am objecting, my lord, because it is delaying because my early hearing petition become infructuous, my lord, because that was allowed. Now that order become redundant, my lord. Earlier, I have not objected that it may be substituted. On expiry of 1 month, my lord, your lordship may deem it service My lord, hearing may be taken place. I have no objection. Any day hearing. I don't have any objection. And this has already been
and
issued.
because of
Now
the
this
delay,
argument has been placed.
now because of the delay, my lord, because of the delay, the Assam Mala has been road has been passed away from our land. We are staying now. Our land house is demolishing, and we are not getting the
This is the real
money also.
objective to get the money.
We are not getting the money also. So let since there is an order of the single bench in writ petition that this injunction order, that is amount should not be disbursed subject to outcome of this second appeal, my lord. That is why I filed an early hearing petition that was allowed by your lordship. Your lordship has allowed after going through the record. And now this early hearing order has been become redundant because of all this defective filing, not maintainable, nothing.
No, sir, here it was that number in not it not that job.
Yes. My lord, my lord.
Sent with the notice
Yes.
to him.
Because he was not contested. He was not contested. And ex-party from all along, not necessary party also. Because of my urgency, I have considered that let the prayer, that their prayer be allowed.
But complaint,
And they will not contest because all along they have not contested.
maybe
And pro forma,
that notice
they are not main defendant also, main respondent also. They are the pro forma.
when
And kindly see the miscase, my lord. Defective miscase, my lord. How it has been listed, that also I do not know, my lord. Kindly see the
you go to the file a complaint, how
how.
they have registered.
Yes. No, earlier it was not registered. It was become defective. Subsequently, it has been came into the court, my lord. Kindly see the IA, my lord. Kindly see the IA. No respondent has been made out except 16. I kindly see the IA.
They when
And 2 weeks back, madam. Immediately, madam, we have taken steps.
Earlier service
Ek
through
traffic.
personal service was also allowed. Dosti service was also allowed by this honorable court.
My lord.
We are not in the IA, we are not respondent. They are also not respondent. No respondent, only one. Kindly see the IA.
then why you are appearing?
In main case, we are appearing.
They are not taking the maintenance.
We are the main respondent here in this case, my lord.
But you are not a party.
That is why I am submitting that it is a defective, my lord.
They
Yes.
after
That I said.
May it please, Lordship. If IA 2293, as per the last order dated 20/7, they were supposed to file any objection if they wish.
No, we have not filed. We have not filed. Lordship may take up the IA.
If that be the case, my lord, I was in the impression they may file because the order says so. They have not filed. Let it come up next week. My senior Mr. N. Deka will argue that.
I think this pending. If this remains pending, we will be suffering because we are already suffering. Matter is not.
My lord,
And what
that in
no,
that the matter.
They have filed this IA to introduce certain new documents. They say that they were not earlier aware of all these things. Let these new documents be taken up, but only one submission from our side may kindly be recorded that these documents, according to us, are not relevant. With that, your lordship may allow this IA. They have filed the IA under Order 41 Rule 27 to leave to produce additional document, additional evidence. Order 41 Rule 27 says leave to adduce additional evidence at the appellate stage. So, lordship may kindly. No matter, I say their petition may be allowed. Only my submission that it is not relevant that may be recorded. Otherwise, the petition may be allowed. This will expedite the disposal. Otherwise, it has remained pending for a pretty long time.
If petition is allowed, relevancy will come up at the stage of final hearing. Whether it is relevant or not, your lordship will decide at the stage of final hearing.
My lord, otherwise, my lord, if your lordship goes to the principle of Order 41 Rule 27, it says at the time of final disposal of the appeal, this has to be considered. So, with this observation, lordship may fix the matter for final disposal. Along with that, your lordship will take up. Because Supreme Court is very clear. It says that at the time of final disposal, only Order 41 Rule 27 has to be taken into consideration. Ibrahim Uddin's case, lordship is aware of that. Simanto Das, S. Das. In terms of the Ibrahim Uddin judgment.
In terms of
The judgment of Ibrahim Uddin,
it is
2012 HSSC 149. 2012 HSSC page 149. Ibrahim Uddin versus Union of India. Ibrahim Uddin versus Union of India. Well, one submission from my side that according to me these documents are not relevant. As my submission. No matter, I'm not saying your lot will decide. My submission I have made. That's me. As these are not relevant. Here's my submission. My obliged. Lot may kindly fix the date so that on a hearing day. Any day, 11th September. Obliged.
See, let's pass over for the timing. For the timing pass over, material pass over.
timing.
Lordship, can you see one thing? Order dated 26, your Lordship's order, the matter was fixed for final consideration. So, matter ought to have come for hearing also.
But the matter has been disciplined here. But the matter is in the last column, it's in the order list only. The order column only. Lordship may let the English Council come. Then put forward is part of argument. Sir.
Before hearing,
Yes, Lord.
Lordship, let the Anchors Council come, Lordship, today. For a timing, I am paying for.
So in this suit, where the defendant and the respondent plaintiff filed a suit for declaration of right title and interest and partition of the ancestral property as claimed by them. The suit was dismissed. In the suit, we filed counterclaim also for adverse possession. The suit was dismissed and the counterclaim was allowed. They filed an appeal, one appeal, in fact, challenging the judgment and decree passed in the suit as well as in the counterclaim. So the appeal was allowed, holding that the suit property is the ancestral property of the plaintiff, and the counterclaim was the finding arrived at by the learned trial court in the counterclaim has been reversed, holding that it is the burden on the part of the counterclaimant, that is the defendant in the suit, to prove as to since when the land is under the possession of the defendant and which is the specific date. Since there is no specific date mentioned of possession and which is adverse to the original owner, so the plea of adverse possession is not maintainable. For my convenience, I have prepared a chart describing the family tree. Yes. Not a book. Yes. So total
Your
land,
Lordship, before my learned friend starts, let's point out on page 64, if your Lordship says, here their adverse possession has given up the adverse possession. Take page 64 is recorded here. 64 of the trial court judgment. It is recorded by trial court. In his cross-examination, DW1 stated that at first they filed a written statement counterclaim and had taken the plea of adverse possession. Thereafter, the 64. Thereafter, DW1 and DW2 has filed amended written statement, and in the amended defendant 1 2 has not taken the plea of adverse possession here. They've given up the adverse possession here. It's recorded by trial court here. There's no point arguing on the adverse possession because he cannot. He has given up the plea by amended WS your Lordship. That is amended WS is on the record your Lordship.
but there are two written statements filed by the defendant number 1 and 5 and defendant number 6 to 8. In the amended written statement, defendant number 1 to 5 has not taken the plea of adverse possession. But so far as defendant number 6 to 8 are concerned, there is a plea of adverse possession and the finding is recorded at page 67 of the trial court judgment.
Your Lordship, my learned friend is appearing for whom? Defendant 1 to 5 first is defendant 1 to 5 also.
This
He
is the,
cannot take the plea 68 to bring adverse possession to the back door your Lordship. When he's given up the plea.
I am just replying to what the learned counsel for the respondent has submitted before this honorable court, that there is no plea of adverse possession been taken in the written statement. I am just clarifying this honorable court on behalf of the other defendants also.
Yes.
So the total land involved in this suit is 4 katha, 4 biga, 1 katha, 1 lecture. And the plaintiff and the defendant number 1 to 5 are the step brothers and the legal heirs of their predecessor. So the plaintiff claims that over the land measuring 4 bigha, 1 katha, 1 lecha, they have the right, and there was a oral partition being entered into between them, and that's why they are entitled to 1/3 of the total share of the land. So the learned trial court came to arrive at a finding relying on the Exhibit 5 or Exhibit 6 document that some portion of the land has been purchased is the self-acquired property of the different number 1 to 5. The total land measuring 3 katha, 3 katha, and so 3 katha 18 lecha is the land purchased by the different number 1 is the self-acquired property. So minus that, they may be entitled to the ancestral property. But the finding arrived by the learned trial court that the entire property should schedule land So entire property is not the self-acquired, is the ancestral property of the predecessor of the plaintiff and the defendant. And since there is an admission in the evidence of the defendant witnesses that they have not been residing in the on the plot of land since more than 60 years, or by their own admission, they have admitted that they have relinquished their right over the property. So in this manner, the plea of adverse possession was decided in favor of the defendants, and the suit filed by the plaintiff was dismissed relying on Exhibit 5 or Exhibit 6 document, which clearly says that 3 katha 18 lechas of land was purchased by Mr. Dhaneshwar Gogoi, the predecessor in interest of the defendant number 1. So naturally, and there is a evidence also, DW5, the official witness who has verified with all the documents brought before the court, there is an entry that the 3 katha 18 acres of land has been purchased by the predecessor of the defendant number 1. It's a self-acquired property, so there is no question of partitioning the land, and the entire suit property is not the ancestral property of the plaintiff. But while considering in appeal, the learned first appellate court did not consider the document. The learned first appellate court relied on a document of entry of 1946, as per which some portion of the land has been purchased jointly by some of the co-sharers. Whereas the evidence of DW5 is concerned, who has adduced before the Honorable Court with the relevant documents, Exhibit F or Exhibit 6, there is no finding of the first appellate court. So that's why a substantial question of law was framed by this Honorable Court. So whether the judgment and decree passed by the learned first appellate court is perverse due to non-consideration of the relevant documents on record. So if I may take your lordship to the trial court judgment, page 57.
Number
Page 57 of the memo. The issue number 6, whether the plaintiff has right title in the 1/3 share of the total A suit land. From the above of the pleadings of both sides, the admitted position is that the plaintiffs and defendants are the step brothers, and the father of defendant number 1 to 5, namely Moheshwar Gogoi, was the son of late Meyuka Gogoi. The plaintiff number 3, in order to prove their case, has brought on record his testimony as PW1. PW1 has submitted and supported the contentions of the plaintiff. In his cross-examination, he admitted that they had mutated their name in the suit land in 2002. He also stated that he had an old copy of Jamabandi, but he did not bring it to the court. He further stated that PW1 had not submitted any document regarding sale instrument by Dhaneshwar Borwa regarding the suit land. PW1 has himself admitted that the suit land was enjoyed and possessed by the Moyeshwar Borua and Pyari Mohan Borua since 1952. It is the admission of the PW1, the plaintiff witness. He has also stated that his father was expired in the year 1995. From 1952 till the death of his father, the plaintiff and his deceased father had not taken any steps for the suit land. PW1 has admitted in his evidence that Dhoneshwar Borua was not the father of the Moyeshwar Gogoi. The real father of Moyeshwar Gogoi was Meuka Gogoi. PW2 has stated in his evidence that the suit land was possessed by Dharmeshwar Borua. He had three sons, namely Moyeshwar Gogoi, Ramakanta Borua, and Pyari Mohan Borua, which was contradicted by PW1. They had inherited their father's property. PW2 supported the contentions of the plaintiff. In his cross-examination, PW2 submitted that he did not know who had purchased the suit land. He admitted that Ramakanta Borua had left the suit land after 1 year of Ramakanta Borua's marriage, which is approximately 60 years. Ramakanta Borua is the predecessor interest of the plaintiff. He further stated that at the time of Ramakanta Borua's marriage, Pyari Mohan Borua and Ramakanta Borua were living as a joint family. After leaving of Ramakanta Borua, Pyari Mohan Borua was living in the suit land, and after the death of Pyari Mohan Borua, his family were living there. He further stated that there was an oral partition between Pyari Mohan Borua and Ramakanta Borua. Therefore, defendant number 6, 7, 8 had enjoyed and possesses the suit land. PW3, Lat Mandal of Chariduar Revenue Circle, in his evidence stated that in Exhibit 5, there were 7 patadars. The serial number 1 name is Binod Borua. We are not related to Binod Borua. Serial number 2 and 3 are Digola Gogoi. Digola Gogoi is the same name, another name of Ramakanta Borua, the predecessor interest of the plaintiff. And Pyari Mohan Borua. Serial number 4, 5, and 6 are Rupeshwar Gogoi, Uttam Gogoi, and Tonkeshwar Gogoi respectively. The total land measuring under DAG number 275 and patta number 73 is 6 biga 1 lecha. The portion of the land had not mentioned there. The 7 names were inserted at the time of settlement. On 1/3/2002, the names of the plaintiffs were inserted. DW2 also stated that long back plaintiff's predecessor, late Ramakanta Borua, had gave up his share of the suit land. It is the evidence of PW in favor of his younger brother, Pyari Mohan Borua. DW3 had also stated in his evidence that Ramakanta Borua had left his suit land and relinquished his share and gave to Pyari Mohan Borua, which was supported by PW2. From the foregoing discussion of evidence and the reasons, it transpires that plaintiff's father Ramakanta Borua had purchased the suit land jointly, which is admitted by the defendants, and approximately 60 years ago, Ramakanta Borua had gave up his share to his younger brother, late Pyari Mohan Borua. Apparently, from the pleadings itself as well as the evidence rendered, it is clear that the plaintiffs do not have possession over the suit land. The plaintiffs have shared land on the suit land, but plaintiff's side has failed to prove that the suit land was owned and possessed by late Dhoneshwar Borua. Plaintiffs also failed to prove that the sons of late Dhoneshwar Boruas, namely Moyeshwar Gogoi, Ramakanta Borua, and Pyari Mohan Borua, had agreed equally to divide the suit land as 1/3 share of the total A suit land. As PW1 himself admitted in his cross-examination that late Moyeshwar Gogoi was the son of Meuka Gogoi. DW5 in his evidence stated that DW5 is the official witness, that Exhibit 5 is the Jamabandi book of 1930 of Revenue Village and Moja, Goroimari. Exhibit 5.1 is the Jamabandi of Patta number 92. Exhibit 5 F1. F1. There was only one duck, number 258 in the said Patta. In the said duck, there were total 6 bigas, 8 lechas land. Moyeshwar Gogoi, son of Meuka, was the original Pattadar, serial number 8. As per note dated 2841 of the said Jamabandi, land measuring 3 kathas, 18 lechas was mutated in the name of Moyeshwar Gogoi by way of purchase from Ghano and Norendra. Exhibit 6 is the Chitha book of Jamabandi Dak number 274, identified by PW3. Exhibit G1 is the Chitha of Dak number 258 of Revenue Village, Nij Goremari. The Dak number 258 was converted to Dak number 275. Total land of the said Dak was 6 bighas, 1 lecha. Exhibit 8 is the draft Jamabandi of village so is the draft PP number 79. As per the said draft, Jamabandi old Dak number 258 converted into Dak number 275. DW5 also stated in his evidence that another note dated 13/11/46 in the Jamabandi reflects that as per the order 17/7/46 of the said Jamabandi, name of Moisture Dighola, Piari and Sarulara has been mutated by way of purchase and possession in place of Khanwa and Narendra. Therefore, it was clearly established that plaintiff's late father had purchased the land in the same Dak. From the evidence of the plaintiff and the defendant, as discussed above, I find the evidence of defendants more probable. In view of the evidence as discussed, I am of the considered opinion that the preponderance lies in favor of the defendant. Therefore, the plea of the defendant seemed to be more probable and believable. Hence, this issue is decided in negative against to the plaintiff. Well, the main crux of the matter is the Exhibit 5 F and the F1, where there is a clear entry that a land measuring 3 katha 18 lecha was purchased by the father of the defendant number 1. That is Moheshwar Gogoi, and it was the self-acquired property. So entire suit land may not be the ancestral property of the plaintiff as claimed by them, and on this ground the right title interest, the issue number 6, was decided against the plaintiff. How about the learned first appellate court reverse the finding? If I may take your lordship to page 105, the memo of appeal, to show how the learned first appellate court has dealt with the issue. It starts from 104. You may skip the first page. You may start from paragraph 21, 105. The lordship has got. The learned trial court found that the plaintiff and the defendants were the stepbrothers. The father of the plaintiff was one late Ramakanta Borua, and father of the defendant number 6 to 8 late was Piari Mohan Borua. Both Ramakanta Borua and Piari Mohan Borua was the son of one Dhaneshwar Borua. Father of defendant number 1 to 5 was one Mohesh Gogoi, and he was the son of one Mehuka Gogoi. The learned trial court took the view of evidence of PW1, wherein he admitted that he did not file any instrument concerning right title interest of Dhaneshwar Borua of the suit land. The PW2 also admitted in his cross-examination that he did not have any knowledge who had purchased the suit land. The learned trial court in paragraph 46 in her judgment found that the father of the plaintiff's late Ramakanta Borua had purchased the suit land jointly, which the defendant admitted in his pleading and evidence. But Ramakanta Borua gave up his share to his younger brother late Piari Mohan Borua. The learned trial court also examined one independent official witness with relevant record in respect of the suit land. The court examined Exhibit 5, wherein she found 7 numbers for pattadars, including the father's name of the plaintiff Ramakanta, alias Dighola. However, in Exhibit 5, the total land was 6 bigha and 1 lecha, but the witness could not ascertain the individual portion of land of each pattadar. I have also perused the Exhibit 5 and found that the names of the present plaintiffs were entered into the Jamabandi. In such circumstances, where the record of right suggested that the names of plaintiffs have been recorded as pattadar, the decision of the trial court discarding the right title interest over the suit land is found unjustified. Is not found justifiable. The learned trial court viewed in reference to the pleading and evidence of the plaintiff that predecessor of the plaintiff gave up a share to the predecessor of the defendant number 6 to 8, and they were in the possession over the suit land for more than 12 years. The predecessor of the plaintiff during his life did not file any case against the defendant over the suit land. During the trial, the learned court scrutinized a jamabandi of the suit land, which was marked as Exhibit 5. In the Exhibit 5, there found only one dug being number 258, total land being 6 bigha and 8 lecha. In the said patta, name of late Moisture Gogoi was mentioned as original pattadar having his land about 3 katha and 18 lecha by purchase from one Ghono and Narendra. The learned trial court also perused Exhibit 6, which was the Chitha book of Jamabandi Dag number 274 and was identified by PW3. He also perused this Chitha of Dag number 258, which was subsequently converted into Dag number 275. In para number 46 of the judgment, it is found that the learned trial court took the view of a note dated 13/11/1946 inserted in the Jamabandi. It is found therein in the note dated 17/7/1946 that names of Moisture Gogoi, Dihola Ramakanta, Pyari Mohan and Soru Lora has been mutated by way of purchase and possession in place of Ghono and Narendra. In view of that, the learned trial court affirmed that the father of the plaintiff purchased the land over the same Dag. Therefore, where the learned trial court itself affirmed the right of the plaintiff on scrutiny the evidence on record, determining the issue against the plaintiff is indeed wrong and need to interfere. The learned trial court viewed that the predecessor of the plaintiff relinquished his right over the suit land. He left the suit land and shifted his residence to some other place. The learned trial court denied the right title interest over the suit land of the plaintiff on the principle of adverse possession. The learned counsel appearing for the plaintiff appellant submitted that where the defendant respondent claimed their right over the suit land on adverse possession, the right title interest of the plaintiff appellant cannot be denied, and it is admission by the defendant. In para number 52 of the impugned judgment, the learned court admittedly found that the suit land was not owned and possessed by the grandfather of the defendant respondent, Dhaneshwar Bora, but owned by Moisture Gogoi, Ramakanta Pura and Pyari Mohan jointly. Where the learned trial court, from her own finding, found that the predecessor of the plaintiff's appellant was the joint owner of the suit land with the defendant and the pro forma defendant. In such circumstances, denial of the right of the plaintiff is absurd and need to be rectified. The names of the plaintiffs appear in the Jamabandi with the names of the defendant. Hence, relying the evidence of both the parties and these documents submitted thereof, it is of the view that the plaintiff have right title interest over the Schedule B land or 1/3 share of the Schedule A land. But there is no discussion of the 1941 document, which clearly says and corroborated by the official witness DW5 that a land measuring 3 kathas, 18 lechas out of the total land has been purchased by the predecessor interest of the defendant number 1 to 5. And it is the self-acquired property of the defendant number 1 to 5. Not the land purchased by the predecessor interest of Ramakanta Borua. So this finding, in my humble submission, is perverse for not considering the evidence Exhibit F document, which clearly says this is a 1941 document entry in the Jamabandi, corroborated by the DW5, the official witness, that a land measuring 3 katha 18 lechas has been purchased by the father of the defendant number 1, and it is a self-acquired property of the defendant number 1. So they cannot claim the share in the land which has been purchased by the which is a self-acquired property of the predecessor interest of the defendant number 1 to 5. So far as the other issue is concerned, it is issue number 8. The Lordship will find at page 67. whether the defendants have acquired right title in the Schedule B by right of adverse possession. Page number 67 of the final court judgment. The defendant number 6 to 8 have taken the plea in their written statement as well as counterclaim that since the Mohan Borua and Sarulora Borua in Exhibit F1, a note dated 13/11/46 in the Jawamandi reflected that as per order dated 17/7/46 of the said Jawamandi, name of Moisture, Dighola, Piari and Sarulora had been mutated by way of purchase and possession in place of Ghano and Norendra. DW2 and DW3 had stated that long back, plaintiff's predecessor late Ramakanta Borua had gave up his share of the suit land in favor of his younger brother Piari Mohan Borua. The father of defendant number 6 to 8 had settled about half kilometer from the suit land. The defendant number 6 to 8 and their deceased father had possessed and enjoyed the suit land since then to till the filing of the suit. PW1 also admitted that Ramakanta Borua had left the suit land after 1 year of his marriage, which is approximately 60 years ago, and confirmed by PW2. PW1 further stated that there was an oral partition between his father, page 69. There was an oral partition between his father Ramakanta Borua and Piari Mohan Borua. PW2 stated that at the time of Ramakanta Borua's marriage, Piari Mohan Borua and Ramakanta Borua were living as a joint family. After leaving of Ramakanta Borua, Piari Mohan Borua was living in the suit land, and after the death of Piari Mohan Borua, his family were living there. Therefore, defendant number 6, 7, 8 had enjoyed and possesses the suit land after the death of their father with the knowledge of the plaintiff. PW1 has himself stated that the suit land was enjoyed and possessed by the Moisture Gogoi and Piari Mohan Gogoi since 1952. Plaintiffs had exhibited the revenue-paying receipts only for the year 2012, whereas the defendant side had exhibited the revenue-paying receipts from the year 1978 to 2012, which clearly establishes the fact that defendant number 6, 7, 8 had enjoyed and possesses the suit land. The learned counsel for the plaintiffs had argued that the plea of adverse possession by the defendants cannot be taken as, firstly, in the instant case, it was a permissive possession, and secondly, defendants were co-owners. This first position was decided by the Honorable Supreme Court, so and so we may skip, may start from. It was held that a plea of adverse possession by a co-owner can be taken if that person is able to prove that he has ousted all the co-owners from the property coupled with all the other ingredients to constitute adverse possession. As per the judgment, there are 3 elements are necessary for establishing the plea of ouster in the case of co-owner. They are declaration of hostile animus, long and uninterrupted possession of the person pleading ouster, exercise of right of exclusive ownership openly and to the knowledge of the other co-owner. In the instant case, it clearly reveals that Ramakanta Borua had himself left the suit land and gave up his share to his younger brother to enjoy and possess the suit land. Therefore, the plea of adverse possession by the defendant number 6 to 8 cannot be rejected. Then we may start from paragraph 63. In the instant case, the plaintiff's father had relinquished his right to his younger brother and left the suit land approximately 60 years ago. The defendants by documents and evidence also has proved that they had been enjoying the suit land adverse to the title holder's interest after making them known that such enjoyment is against their own interest. By pleading and evidence, it can be held that the defendants have succeeded to prove their claim. Hence, this issue is decided in affirmative to the defendant. Now, the learned First Appellate Court, while deciding the issue number 8, has reversed the finding, and if I may take a lordship to the finding recorded in the First Appellate Court, page number 111. issue number 8. Whether the defendants have acquired right title in the entire B schedule land of adverse possession. The issue number 8 is framed in the form that whether the defendants have acquired right title in the schedule B land by right of adverse possession. It is seen that the issue is also interrelated to previous issue, that is issue number 6 and issue number 7. In issue number 6 and 7, it was decided that the predecessor of the plaintiff and the predecessor of the defendant were the owner of the suit land or the part of the suit land by purchase. Their name was accordingly mutated in the record of right. But after their death, the present plaintiff and the defendant took their feet to step. The issue was framed in favor of the defendant number 6 to 8, and the learned trial court scrutinized the evidences of both the parties. The plea of the defendant was that they were enjoying the suit B schedule land since 60 years without any interruption from the plaintiff, and hence they have their right title over the B schedule land. In deciding the issue, the learned trial court took the view of a case law decided by the Honorable Supreme Court, so and so. It was held that any person who claimed the title over the property on the strength of adverse possession, his case must be over the true owner, that is, they must admit the ownership of the true owner. And the true owner has to be made party. In the instant case, the learned trial court found that the predecessor of the plaintiff and the defendant jointly purchased suit land and was the joint owner. However, from the evidence laid by the ideal parties, it was found that the suit land was measuring about 4 biga 1 katha and 1 lecha, out of which 3 katha and 3 lecha was purchased by the grandfather of the defendant number 1 to 5, and rest amount of land measuring 3 biga 2 katha and 3 lecha was jointly purchased by the predecessor of the plaintiff and the defendant. However, the defendant number 1 to 5 had not claimed over the B schedule land owning to the adverse possession. The defendant number 6 to 8 claimed their right title interest over B schedule land by way of adverse possession. So it is the claim of the defendant number 6 to 8 over B schedule land right title interest on the ground of adverse possession. The learned trial court, in view of evidence of DW2 and DW3, found that late Ramakanta Borua was the joint owner of the suit land, but he left the suit land and relinquished his share to his younger brother, late Pyari Mohan Borua, who was the father of defendant number 6 to 8. Since then, the father of the defendant number 6 to 8 possesses the B schedule land. The learned trial court further narrated in her judgment that during the life of Ramakanta Borua and Pyari Mohan Borua, the deceased father of the plaintiff and the defendant number 6 to 8, there took place of oral partition over this suit A schedule land. But this oral partition was never proved by the plaintiff. They took a plea in the plain that there was an oral partition between the brothers, but they failed to prove the oral partition. And there is a passive finding of the learned trial court about their failure. If that be the position, it is apparent that Ramakanta Borua did not relinquish his portion of land in favor of the deceased father of the defendant number 6 to 8. The father of defendant number 6 to 8 was the permissive possessor over the B schedule land. In regards to the title on adverse possession is concerned, the learned trial court took the view of a case law decided by the Honorable Supreme Court in so and so. In that case, it was decided that plea of adverse possession can be taken up in case of permissive possession when the permissive possession is hostile, adverse to the true or real owner. The learned trial court in another case has decided so and so took the view that a plea of adverse possession by a co-owner can be taken up if that person is able to prove that he has ousted all other co-owners from the property coupled with all other ingredients to constitute adverse possession. The learned trial court in deciding the issue, though discussed the principle of adverse possession, but could not scrutinize the principle correctly. The court only took the plea that the father of the plaintiff relinquished his right in favor of the father of the defendant number 6 to 8, and hence the plea of defendant could not be denied. But if we carefully gone the principle as laid down in the above noted case and as submitted the plaintiff appellant, we found that both the principles are not fulfilled in the case. First of all, the possession over the B schedule land by the defendant number 6 to 8 was a permissive possession by the deceased father of the plaintiff. This finding is only on the basis of the oral partition which they claimed, but they failed to prove the oral partition. Secondly, there is evidence on record that the defendant were not in continuous possession over the B schedule land and their point and time of possession has not clearly been mentioned. This is also finding is without evidence. with due respect. From the material on the case record, it is found that the different number 1 to 5 and different number 6 to 8 are in the initial possession over the B schedule land, and it was only the plea of different number 6 to 8 of adverse possession over the suit land. Here, the different number 6 to 8 took no steps to oust the owner, other co-owner from the B schedule land. The different number 1 to 5 and different number 6 to 8 are claiming that they were in the possession of the suit land. Moreover, the defendant failed to prove as to when and on what date they were in the possession over the suit land and the nature of their possession, and their names were legally mutated in the record of right. The issue was deciding on the admission of both the parties in their pleadings and the evidence. However, so far as quantity of land in Schedule A is concerned, there are found some variances in respect of pleading and the documentary evidences submitted by the either party. The issue number 7, it was decided that the predecessor of the plaintiff and the defendant I'm sorry, Malo, I have skipped one page in between. Page 114. After 113, I said 114, page 114. I'm sorry. Prove that he has ousted all other co-owners from the property coupled with all other ingredients to constitute adverse possession. The learned trial court in deciding the issue, though discussed the principle of adverse possession but could not scrutinize the principle correctly. The court only took the plea that the father of the plaintiff relinquished his right in favor of the father of the defendant number 6 to 8, and hence the plea of defendant could not be denied. But if we carefully gone the principle as laid down in the above noted case and as submitted by the plaintiff appellants, we found that both the principles are not fulfilled in the case. First of all, the possession of the B schedule by the defendant number 6 to 8 was a permissive possession by the deceased father of the plaintiff. Secondly, there is evidence on record that the defendant were not in continuous possession over the B schedule land, and their point and time of possession has not been clearly mentioned. From the material on the case record, it is found that the defendant number 1 to 5 and the defendant number 6 to 8 are in the initial possession of over the B schedule land, and it was only the plea of defendant number 6 to 8 of adverse possession over the suit land. Here, the defendant number 6 to 8 took no steps to oust the other co-owner from the B schedule land. The defendant number 1 to 5 and defendant number 6 to 8 are claiming that they were in the possession over the suit land. Moreover, the defendant failed to prove as to when and on what date they were in the possession over the suit land and the nature of their possession, and their names were legally mutated in the record of right. The issue was deciding here too, which are in the internal page 27. Here too, which are the essential ingredients to be proved. 113. 113. There too, which are the essential ingredients to be proved by the defendant side. Further, the defendant side could not prove whether the plaintiff had knowledge of their adverse possession or was undisputed thereof. Though the learned trial court found that the defendant side were in the possession over the B schedule land since 60 years, but no specific date was found from when the defendant were in possession over that land. Hence, I am of the view that the determination of the learned trial court is wrong. The defendants cannot acquire any right title in the B schedule land by right of purchase. Well, this finding, in my humble submission, arrived at by the learned first appellate court, is not based on any evidence. When there is a clear evidence on the side of the plaintiff witnesses that they have not been in possession since more than 60 years, the duty to prove the date and since when we have been in possession may not be necessary in the facts and circumstances of the present case, because it is by of their own admission that they have not been in possession of the land after the marriage of the late Ramakanta Borua, that is more than 60 years, and there are revenue receipts also. We have shown from 1970 to 2011. They have produced the revenue receipt only of the year 2012, which shows that they have not been in possession, and their residence is half a kilometer away from the main suit land. So the plea of adverse possession, the decision arrived at by the learned first appellate court, is based on no evidence, because when the parties themselves have admitted that they have not been in possession for more than 60 years, and so far as the learned first appellate court relied on an oral partition, that oral partition was never proved. by the party. The plaintiff failed to prove that there was any oral partition arrived at between the brothers to apportion the share on the ancestral property. So these are the two issues decided by the learned first appellate court. One is without considering the document, that is Exhibit 5, wherein there is a clear admission that a land measuring 3 katha, 18 letters has been purchased by the father of the defendant number 1. And the adverse question, plea of adverse question, the learned first appellate court relied on a submission made on behalf of the plaintiff that there was an oral partition arrived at between the parties, which was never proved. In my humble submission, the issues decided by the learned first appellate court are not correct because of non-consideration of the documents on record and taking into consideration some relevant facts, irrelevant facts, which are never proved by the plaintiff side. And so far as the confusion regarding the total area of land, that is 6 biga 1 lecha, is concerned, it is very clear because the patta includes other name also. Some Borua's name is there, who is also in the, whose name is also was appearing in the Jamabandi. The total land of the patta is 6 biga, but the total property of, including the property of the predecessor interest of Ramakanta Borua, Pyari Mohan Borua, and the present defendant is consisting of 4 bigha, 1 katha, and 1 letter. And out of that, clearly, a land measuring 3 katha, 18 letters has been purchased by the predecessor interest of defendant number 1. So that being the position, the finding arrived at by the learned first appellate court may not be correct in my submission. And the substantial question of law framed by this honorable court may be decided in favor of the appellant. On the last occasion, I submitted before this honorable court that there is no point for determination. I've gone through the judgment Your Lordship indicated on the last occasion. The judgment says that if the issues are decided, entered issues are decided and discussed by the first appellate court, then there is no need further requirement to specifically write that these are the points for determination if the issues are discussed. So here, what we have found, the issues are discussed, all the issues were discussed by the learned first appellate court. I am not pressing that issue, point for determination. But on the ground of perversity and non-consideration of the materials on record, the substantial question of law may be decided in favor of the appellant. Yes.
Then you have considered the number.
I've not, this point for determination may not be necessary because all the points, all the issues has clearly been discussed by the.
But not pressing.
Yes.
For,
Yes. Yes. Because clearly this exhibit F document was not considered by the learned first appellate court. And there is a perversity on the part of the first appellate court while coming to the conclusion that the entire property is the joint family property of the plaintiff defendant. And so far as the schedule is concerned, if I may take your lordship to the plain for a moment, page 23. The schedule consists of 2 ducts. Schedule A, 275 covered by PP number 73. There is 1 biga, 1 kata, 1 lecha. Under duct number 274 covered by PP number so and so. And if we come to the next page, schedule B, 1/3 share. 1/3 share of which land has not been specified. When there is a clear stand by the defendant side that the land, some portion of the land is the self-acquired property of the defendant, then Schedule C, under illegal and excess possession of defendant number 1, which portion of the land is in the illegal possession of the defendant, not clear. Schedule D, land under possession of the plaintiff. Land measuring 4 kata in Schedule A shoot length. Which duct? 274, 275, not specified, and clearly they are not in possession of any portion of the land. They are residing a half kilometer away from the shoot length. It has been established by the evidence of the parties.
Yes.
Some part, perhaps my learned friend.
Then my portion is also extensively argued by my learned friend. So I'm adopting the arguments. That apart, I'll like to point out 2 or 3 small things, Your Lordship. The suit was initially dismissed. The suit was initially dismissed, and the counterclaim was decreed. The counterclaim, if I may take Your Lordship, the counterclaim of the defendant, page 36 to 40 of my memo. Is a joint counterclaim by all the defendants. Page 36, annexure 3 of my memo. Counterclaim of the defendants as plaintiff and the plaintiff as defendant. It is written like that. So here all the defendants became the plaintiffs of the counterclaim jointly, and adverse possession was claimed. But as the judgment of the learned first appellate court was being read, Your Lordship, the learned first appellate court was, while deciding the matter in the appeal, Your Lordship, was of the view that only respondent number 6 to 8 has prayed for adverse possession and not all the defendants have prayed for adverse possession. However, on papers, Your Lordship, the counterclaim is a joint counterclaim. And apparently there is no written statement by the plaintiff against the counterclaim. Your Lordship. Under such circumstances, the counterclaim was decreed. Whether the plaintiff without any written statement that is one aspect that I was submitting. Second aspect, Your Lordship. I cannot find it from the record.
In fact, there is no issue frame on counterclaim.
Because there was no. I have inspected that apart, Your Lordship, there is a finding in the counterclaim that there is no specific averment as to from what time the defendants are in possession of the suit land. As such, adverse possession cannot be granted. Your Lordship. If we come to their plaint, which is page starts from page 7 in my memo of appeal. In page 11, Your Lordship, para 9, they say, it is their statement, however, the middle portion of 1 bigha 2 kattha of the land fully described in the Schedule B, hereunder earmarked as 1/3 share in the Schedule A land as the distinct share of the plaintiff. Paragraph 9, Your Lordship, page 11. 9. As the learned appellate court has said, there is no specific averment as to when the possession of the defendant was there as to allow adverse possession. There is a condition. Paragraph 9 of the plain. It is in page 11 of my memo.
Paragraph 9, or 14.
14. In RSA number 26. Same thing.
Same matters are different. Page number are different.
Page number.
Where the documents are same.
There, page number
11.
Here it is 14.
That, however, the middle portion of 1 bigha 2 katha of land fully described in Schedule B hereunder earmarked as 1/3 share of Schedule A land as the distinct share of the plaintiff has been remained physically unoccupied by living therein, or there being no structures raised thereon by the plaintiff. It is a plaintiff's case that the middle portion of the entire plot of land, that is, which they are claiming to be 1 bigha 2 katha of their share, Your Lordship, as per an oral partition that they are claiming, which was never proved. It is their statement that it was never occupied by them. And as against this statement in our written statement, Your Lordship, para 27, page 27 in my memo of opinion. Page 27 is a part of the written statement of the defendant. In the second line, Your Lordship, it is clearly specified. It is submitted herein that the defendants are in possession of the suit land much prior to 6/5/1995, the date when the plaintiffs has claimed possession of their share in the suit land. Page 27, Your Lordship. It starts from the second line, the top second line. It is submitted herein that the defendants are in possession of the suit land much prior to 6/5/1995, the date when the plaintiffs has claimed possession of their share in the suit land, which was denied by the defendants. Since then, the defendants are in hostile possession of the suit land continuously and uninterruptedly for more than 12 years. The possession of the defendant in the suit land have therefore become adverse against the plaintiffs, and such right, if any, the plaintiffs had over any portion of the suit land, and the same has been extinguished by long, continuous, uninterrupted, and hostile possession of the defendants in the entire suit Schedule A land, including the Schedule B land. Here is the specific statement as regards the possession, Your Lordship, hostile possession. That apart, Your Lordship, the defendants have exhibited land revenue payment received way back from 1978 continuously, as exhibit number E1, E2, E3, Your Lordship, and so on, up to E27. Okay. Exhibit E1 to E27 are the land revenue payment received paid by the defendant starting from the year 1978 onward. E1 is of 1978 and E27 is of the year 2012. And this suit was filed in the year 2012. So from 1978 till 2012, the defendants have been paying the land revenue, and all the revenue received were exhibited by the defendants in this manner. As such,
it is 6/5/1995.
Prior to 6/5/1995, it is stated in that statement, is submitted herein the defendant are in possession to the suit land. Yes, much prior to that date, but on that date they have tried to enter. The sentence, if I may read again, it is submitted herein that the defendants are in possession of the suit land much prior to 6/5/1995, the date on which the plaintiffs have claimed possession. They have tried to claim possession in 1995 of their share in the suit land, which was denied by the defendant. We have denied their claim on 6/5/1995, but we were in possession much prior to that. And from 6/5/1995, it became hostile because they claimed and we have denied. And the suit was filed in the year 2012, Your Lordship, much later. And the revenue receipts, Your Lordship, are starting from the year 78 till 2012, Your Lordship. Exhibit E series, which shows the defendants have been paying the revenue. This is what I wanted to as regards adverse possession, which is my substantial question number 3, Your Lordship, in my case. Regarding substantial question number 1, Your Lordship, that Your Lordship has pointed out about a judgment, Your Lordship, I have also gone through. And I am also not pressing on the substantial question of law number 1 because all the issues are decided by the appellate court afresh, Your Lordship. That is permissible as per this. Regarding this issue number, substantial question number 3, there is another aspect. I have also, my friend is also going through the record. I did not find any written statement as against the counterclaim. And one common appeal was filed against the dismissal of the suit and decree of the counterclaim, Your Lordship. By paying,
Is there any bar?
Lordship, it can be filed provided the court fee is paid, Your Lordship. Court fee is paid. Here only single court fee is paid, Your Lordship, in the appeal.
Leave has to be taken from the court. Common appeal.
But
That is common.
for getting to obtain the leave of the court to fatal.
May not be fatal if provided if he pays the court fee on the counterclaim, because the appeal is valued at rupees 600. The suit was valued at rupees 600, and they have paid a court fee of rupees 80, which I have seen from the record. And apparently there is no court fee paid on the counterclaim. So if the no court fee is paid on the counterclaim, then naturally they have not filed any appeal against the counterclaim. Though they are praising that they have filed an appeal on the counterclaim, in the absence of any court fee being paid on the counterclaim during appeal, it may not be considered. And I have also not found the WS against the counterclaim filed by.
Regarding the second, that is in the third substantial question of law. Regarding the second substantial question of law, I adopt the submission of my learned friend that there is a finding and by the trial court, and there is an evidence which shows that some portion of the entire plot was a self-acquired property of the defendant's father, Your Lordship, the father of defendant number 1. As such, the entire Schedule A property, out of which 3 katha odd was self-acquired property by the father of the defendant number 1, could not be partitioned as a whole. Because the revenue authorities have also deposed by exhibiting the Jamabandi and the note therein, Your Lordship, which stated 3 katha 18 latha was purchased by the father of the defendant number 1 only, and his name was mutated by the rights of purchase and possession. So it was not ancestral property or acquired property that as regards to 3 katha 18 latha. He may be a joint possessor and joint pattadar of the entire property because he purchased another plot of land in the same patta, Your Lordship, within the same Dagan patta. So the entire property could not be partitioned. That is I did not find it.
Against the additional, the amended.
It is very against the.
But I did not find it. Maybe it
Not be there.
it
It
is
is there. So I have read it because I can.
That is all your. That is all my.
Wait there. Wait.
So if I may place two judgments of our High Court regarding the description of the suit property and the non-payment of court fee on the counterclaim. The first judgment is of Moniur Ali. That is, I am relying on paragraph 26.
Mark the paragraph.
26.
Mark the paragraph here.
Yes. I have highlighted it on the first page.
Okay, I will go through it.
Regarding the non-preparation of decree in terms of Order 20 Rule 18, where the partition, the shares are described, and if it is a revenue-paying estate, it has to be sent to the revenue authority under Section 54 of the Code of Civil Procedure for partitioning to describe the share and the allotment of the share to the respective shareholder. And on that ground, also the decree is also not executable, because this is not a decree generally passed in the partition 2. It has to comply with Order 20 Rule 18. Yes, just I am highlighting one.
May please. Well, I'll be using this 17 of 2000. I'll be arguing on this. The records are same, but I'm 17 of 2000. Okay. Kindly take the paper. First, Your Lordship, let me take you to Your Lordship, the plaint, Your Lordship. Your Lordship, take page 13, the plaint. Para 5. That the ancestor of the plaintiff and the defendant, late Dhaneshwar Barua, own and possess considerable landed property and particularly acquired 3 bighas of land under Dag number 275, now covered by PP number 78, and 1 bigha 1 katha 11 lessa of land under Dag number 274, now PP number 102 in village Niz Gorimari under Moja Gorimari Tejpur in the district of Sonitpur, Assam. Both the land under Dag number 270 are adjacent to each other. The total land is 4 bigha 1 katha 1 lessa is fully described in the Schedule A herein. Next passage. That on the death of Dhaneshwar Barua, his successor became entitled to all his movable and immovable properties, and more particularly the Schedule A land described hereunder. There are 3 sons of late Dhaneshwar Barua, and after their death, the heirs and successors of the 3 sons became entitled to all the movable and immovable properties. Now, Your Lordship, I am taking this thing because this fact is admitted in WS, Your Lordship. I am taking Your Lordship to WS, page. It is at page 27, Your Lordship, para 11 and 12. My Lord has got it, page 27. Para 11. That in respect of averment of para 5 of the plaint, that the ancestor of the plaintiff and the defendant late Dhaneshwar Barua owned and possessed considerable landed property and particularly acquired 3 bighas of land under Dag number 275 so and so and Dag number PP number so and so ground government district, and that both the Dag adjacent are each other comprised of 4 are not denied. Next para is where that the averment made in para 6 that death of Dhaneshwar Barua and his successor become entitled to all their immovable and properties and is true. Your Lordship, is a very clear admission here
that this is an ancestral schedule A is the ancestral property and all are entitled for the
Right.
share.
If I may interrupt for a moment, this is not a written statement. We have filed an amended written statement, page 33.
My friend, this written statement is with for them also. Your
What I am saying,
No, no.
after the amendment petition is allowed, we have filed an amended written statement, and the earlier written statement may not be read because the written statement which we have filed after the amendment, that is available at page 33. This is relevant for consideration.
Please. Your Lordship, let me say, Your Lordship will see this written statement and counterclaim of defendants of defender 1 to 8. And the counterclaim is of 1 to 5. Amended, if Your Lordship will see, page 33. Amended written statement is defender 1 to 5. What about 6 to 8? Amended interpretation is 1 to 5, not all of them. Your Lordship, there are confusion has been created by mixing of the two things. Defender number one, this written statement counterclaim was filed on, Your Lordship, this on 16 November 2022 on behalf of defender 1 to 8. Then in the this amended written statement was filed on 5th February 2015 on Your Lordship, page 36, 5th February 2015. This amendment is, if Your Lordship will see, is defender 1 to 5. Here, Your Lordship, defender 1 to 5 abandon a claim of adverse possession, Your Lordship. There, they have given up the adverse possession here. Only in respect to reference 6 to 8, the adverse possession claim is there in the written statement, Your Lordship. Now, the counterclaim and the counterclaim and the amended WS are in conflict, Your Lordship. Counterclaim is saying something, amended WS say, I'll come to those also, Your Lordship. Then Your Lordship will see para 7 and 8 also of the plaint. That come to para page 13, Your Lordship. That during the lifetime of late Maheshwar Goel, late Ramakanta Goel, and late Pyari Mohan Borua, Ramakanta Borua is the ancestor of ours, Your Lordship. All sons of late agreed to divide 4 bighas of land described in schedule equally with respective share, 1 bigha, 1 katha son. Accordingly, late Maheshwar Gogoi and late Pyari Mohan Gogoi opted to take the northern and southern part of 1 bigha katha land respectively, leaving the middle portion of 1 bigha land Ramakanta husband of father also. That the middle part of 1 bigha 1/3 share of land which is mutually agreed upon by late share of Ramakanta Borua, husband of the father of plaintiff number 1 to 4, was lying vacant, and the plaintiffs and the husband and father during the lifetime erected on no new structure thereon. However, late Maheshwar and late Ramakanta, late Pyariman never got their respective shares in Schedule A land revenue partition, but they had their names mutated in both Patta number 70 and 10 Schedule A as Asmali Patta, their joint properties. After the date of late Maheshwar and Ramakanta, the then surviving brother of Pyari Mohan Borua, defender 5, and then surviving sons of Maheshwar and now so and so, plaintiff were mutually demarcated 3 shares in the year 2004. The plaintiff were given 1 bigha 1/2 katha of land, a middle portion of schedule land, and with equal share of defender and other share late Maheshwar on the northern side, and equal share of late Pyari on the southern of the other side, and 1/3 in middle of so and so. Your Lordship will there, WS is saying what? Your Lordship will see that at page 27, para 13, if Your Lordship see. That the para 7 of the plaint during the lifetime of late so and so, the husband of the father of plaintiff are not true and are denied by the defendant. It is submitted that during the lifetime of late Maheshwar or late Ramakanta, the entire land of 4 bighas. Here it is very, they are only referring to here. What is being confused by some other land is brought in. We are not concerned of other land. We are concerned of 4 bighas of land. What they have purchased, they are trying to mingle with the dark. It's not schedule land is very clear. It is 4 bighas so and so, Your Lordship. We are not concerned about the 6 bighas of land. They are trying to confuse the 6 bighas. 6 bighas with someone that I am not concerned. I am concerned of 4 bighas land. 4 bighas. The schedule land is 4 bighas. So we are not concerned the entire what your land concerned. We are concerned of these things. So it is they are trying to confuse the two issues of the thing. They may have purchased the land. That is why we are not concerned. But the question is, schedule A land is 4 bighas. This is the ancestral property, which they have not denied, Your Lordship. Where mutually agreed to divide among Maheshwar only without leaving the Ramakanta. See, Your Lordship will see. Here again, they have admitted here. They are saying, so 4 bigha 4 dark number were mutually agreed to divide among Maheshwar and Pyari Mohan only, without leaving any share for Ramakanta Borua. That means myself, my predecessor. How can they say that? That means they are admitting they say ancestral property, and when they have not given me the share, then according to them, then that the suit was for partition. Then I proceed further. That in the year 1961 to 62, and mutually agreed to divide among Maheshwar and Pyari Mohan only, without leaving any share of Ramakant. This was done in the year 1961, and since then they used to possess the entire suit to exclude later Ramakant. So how can this be a partition? There are two aspects of it. Either it has been partition. If it is, they are saying that I couldn't prove any oral partition. Suppose there is no oral partition, that means property is undivided property now. It remains an ancestral property. Since it was not divided according to them also, and according to this, they cannot divide. On what basis they have deprived my share? Is there any relinquishment did by me? They have admitted I have a share there, but without leaving me. I am the ancestor. They have divided. Question is, how can they leave me? There is no relinquishment need to produce by them. That I have relinquished a share in favor of the defendant number 2 and 6 to 8 fathers. There is no document that only oral statement. How can they be relinquished by an oral with an immovable property also? Then your lordship will see that this was done in the, and then sees that they possess the entire suit land to the exclusive land. That in respect of ever and paride of the, it is submitted here in the allegation of that middle part of land, 1 bigha, 2 katha, 1/3 of share of civil land, was mutually agreed to share of land. The husband of the plaintiff and the father of the plaintiff too are totally false, contrary, and are denied and different. It is also false, as stated in the plain, that their portion of 1/3 was lying vacant. It is utterly false to state that plaintiff in the said paragraph after the death of Maheshwar and so and so surviving brothers carrying on, providing access to national on the east of so and so. Your lordship will see clear the whole things are contradictory. At one point of time, they are saying it has been once they have partitioned the property, leaving my share, it is an ancestral property. And 6 bigger than that, we are not concerned, your lordship. Now, even now, let us come to the counter claim also. If your lordship will see one thing, why counter claim was filed in the month this thing, your lordship. It was filed on 16 November 2022. Why? All the defendants. Now, with the amended written statement, which has not referred to the counter claim at all, they have abandoned the counter. Defendant 1 to 5 had abandoned the counter claim. Because if you lordship you see the amended written statement, there is no mention that they are having the counter claim here. Because once your lordship is, I need not trouble your lordship. Once a WS is there, amended WS, the old WS goes away. Similarly, if the counter claim is there, an amended WS filed subsequently does not take into consideration the counter claim, it is amounts to abandon of the counter claim also by defendant 1 to 5. Now, so far, the counter claim remains for defendant 6 to 8, your lordship. And they have abandoned the plea of adverse possession. Now, what my learned friend was arguing that it is not relevant for him. He cannot place his case taking the shoulder of defendant 6 to 8 to prove it to take benefit of adverse possession. He cannot take it. He has to establish title on his own. Question is, adverse possession has been claimed by defendant number 6 to 8 here at present. Now, what happened, your lordship will see. If your lordship will see, the issues framed by the trial court, your lordship. There is no issue with respect to counter claim. So, may I take to page, your lordship? Issues are framed here, your lordship. Your lordship starts from page 52. My lord has got it. Whether there is a cause of action for the suit and whether there is a cause of action in 2011 or 2020, 2000. Whether there is any cause of action for the counterclaim, whether there arose any cause of action for counterclaim from 1964 on 65, 25, 35 and every subsequent case. Whether this is not whether the counterclaim is barred by limitation. These are the two. Whether the suit is bad for non-gender of necessary party is not whether the plaintiff is at right title 1/3 share is the total scheduled land. This is one of the issue. Whether defendant have right title in the entire scheduled land, including scheduled B land. Whether defendant have acquired right title by right of adverse possession. Whether plaintiff is entitled to decree so and so, your lordship will see there is no issue whether the defendants are entitled to counter. There is no issue framed on that, and no adjudication is there. Only limitation and cause of action. That doesn't dispense with the counterclaim. There is no issue frame on counterclaim. So as a result of that, counterclaim is not an issue here. Then your lordship will see they were raising objection of schedule, your lordship. Schedule has not been defined. Your lordship will see that counterclaim. The schedule given in the counterclaim will be the same schedule is given here, your lordship. Page 41. Page 41, and if your lordship just sitting here, it is page 23, 24, and page 41. If you see your lordship. Page 23 is the plain schedule. The schedule has been defined here. I just read it. Land measuring, page, I am on page 23, your lordship. Land measuring 3 viga under dark number, my lord has got it. Page 23. Land schedule A is total suit land. Land measuring 3 viga under dark number so and so to the covered by PP number 2 and 1 viga 1 katha 1 less under dark number 270 covered PP 1 and village needs Goimari under Goimari so and so bounded by north Vinod Bora so and so south so and so east that the part. Then schedule B is plenty 1/3 land measuring 1 viga 2 katha in schedule A land. Then schedule C is under illegal access opposition defenders of measuring. Now D they have avoided. Now page 41, your lordship. Same thing. Land measuring schedule S, land viga 3 vigas. Dark numbers are covered by PP number 1 viga, so and so lesser dark number PP situated very source. Same land. Then B is 2 viga 1 kata of total lateral land, which I am claiming. Land base. So the schedule, when one they have claimed the relief on the basis same schedule, how can they say that schedule is not defined? Schedule should define the boundaries and everything. Schedule is very clear. They know this is a schedule A. And if schedule A is not there, how can they occupy the property? Schedule A, it is not in the plate. They have stated that schedule A and the land are mixed up. Schedule is separate. It is not their case that any part of the land purchased by has fallen into schedule A. There is nothing in the WS also. If some portion of the land claimed that you have purchased by defendant 1 to 5 falls within schedule A land, then the issue would have come. But here they have not claimed anything that this schedule, the land purchased by falls on schedule B 1 4 viga. 4 viga land there is no statement to that effect that the land purchased by them falls within 4 vigas and so on. No statement in WS. So how can these are two separate distinct property? Question of bringing some purchased land into this state doesn't make it work here. I am not claiming the land which they have purchased. I am on the schedule A land which is ancestral property. So your lordship will see here. Then your lordship will see the P of adverse position taken by them. I'm coming one by one issue. Adverse position. Adverse position, if your lordship will say, I'm giving some judgment, your lordship. How adverse position is claimed? For claiming adverse, for claiming adverse position, there are certain requirements. You cannot claim adverse position here. it is, if we say the property is not partitioned, it becomes joint property. So how can there be adverse possession when the of a property with respect to the property which accordingly has not been partitioned by, because there is the, because they said I make a plea of oral partition which I cannot be, which I couldn't prove. That means if the oral partition is not proved, admitted that property has not been partitioned. If that is not partitioned, all are joint owners. Where is the question of my giving a share to them? All correct. Well, there is no question of if I don't have a share, how can I relinquish the share to him? Relinquishment will come when the property falls with me and I have abandoned it. They are saying no oral partition, the property has not been partitioned. They are claiming that these are the, so your lordship, the facts has been really jumbled up, your lordship. The issue is, if a property is there, if it is partitioned, and I can relinquish, and there has to be a relinquishment deed, registered relinquishment deed, because immovable property. Nothing has been, only by I stay 6 kilometers, I didn't stay for 6. It is permissive possession. It is joint, your lordship, joint ancestral property. I may stay in Delhi, but my brothers here cannot say, oh, he's staying in Delhi, he is not entitled for a share here in Guwahati. So that because the ancestral property, parental property, I say, he's not, he stays away from in Delhi, he doesn't stay in Guwahati, also he doesn't, he can't make a claim of the ancestral property. That is not a logic here, lordship. So which the trial court has gone into it. That is not an issue, your lordship. Now, adverse judgment. 2017. 13. The judgment is referred, I just said.
Adverse.
Yes, well, certainly, your lordship. You cannot claim adverse possession. It has to, you have to admit that I am the true owner. And I am the true owner, and the possession is hostile to me. I am the true owner, and I am possessing hostile to the title of it. Here they have not admit I am the true owner. The admission is not there. They have to admit that I am the true owner and possession is hostile to them. So it cannot be done. Yes, I give the judgment to a citation of judgment. That is. So now you will see. There are two judgments if I lordship. I'm passing on the judgment. I have not marked the paragraph there. It's a very short judgment. Now, your lordship, my learned friend was relying on some exhibits, your lordship. Your lordship, I showed that exhibit 5 and 6, your lordship. It's the names of the persons, these people are there. Your lordship, these are exhibit 5 and 6, which my learned friend has relied. Yes. I give photocopy of the original, that will be handy for you. Your lordship is exhibit 5, if your lordship will see. Very nice. Your lordship will just set up this remark column, your lordship. Our name is there. If your lordship see, they have put Dighola, he said Ramakanta Borati. Gogo is only there, but they have confused the Gogo title everywhere. Dighola, Gogo is to be there, Ramakanta Borua. His name, he's not Dighala also. Then his wife, Srimati Pramila Borua, then Jatin Borua, these are all petitions. These names are there, your lordship, in the Jamabandi exhibit 5. Similarly, in exhibit 6 also same thing is there, your lordship. The names are there in the remark column. And so far, my learned friend has relied on the exhibit, which one? F. Exhibit F, this one is not readable actually. It's very here your names are there, your lordship. From the record, if you lordship see, exhibit 5, this is exhibit F, no? The names are not readable that way, no? Your lordship can make out the diagram. Your lordship is exhibit F.
Exhibit
F. Which my lordship? Because exhibit F, according to this affidavit, it says only with respect to dark number, only one dark number says 258 only. Jama, there is only one dark number. It is page 84 also. In the impugned judgment, the High Trial Court judgment, it is mentioned exhibit F. The Jama Bandi of Patta number 92. There was one dark number and a state Patta. So many names. The names are not readable here. That's why it's not possible. Your lordship will see PW1, my lordship was referring PW1 cross CS. PW is my PW1 cross, if you want to evidence. Last page, I just read that portion. Cross of PW. Your lordship see the last. I am not good at I'm not very good at it.
এই গোচৰে মাটিত বাদী আৰু বিবাদীখনৰ মাজত কোনোদিন আপোচ বা ভাগ বতৰা হোৱা নাছিল।
which part you were reading?
Last
Cross of PW1.
last page.
Cross of PW1. Last
Yes.
At the top.
Which part?
It is given 9.
9.
Yeah.
Yes.
First time. এই গোচৰীয় মাটিত বাদী আৰু বিবাদীগণৰ মাজত কোনোদিন আপোচ বা ভাগ বতৰা হোৱা নাছিল।
So this because the exhibit 5 and exhibit 6 they are considered the names of these people also. They are joint Patta. The names are there. Now I take your lordship to this. My learned friend has to refer to the issues. I also take the liberty of that. Your lordship will see issue number 6, page 57. My lord has got it. No, sorry, I'm your lordship, sorry. Yes, sir. Your Lordship, Your Lordship, turn page 57, Your Lordship, of the paper. Your Lordship will see page 40. Page 57, para 40. Here in the middle, if your Lordship, the suit is not for partition of ancestral court. That is the view taken by trial court, Your Lordship. But if your Lordship see the prayer in the plain, it is for partitioning of the property. Here, trial court's observation, Your Lordship. They said it is not for partition of the suit property, Your Lordship. Whereas the relief sought in the plaint is, if your Lordship, page 22. Page 22, prayer in the plaint, Your Lordship. That my Lord has got it, page 22. That the suit, my God is there, that the suit be decreed that the Schedule A suit land in the ancestral property of the plaintiff and that the plaintiffs are entitled to 1/3 share therewith, with consequential relief of separate possession of 1/3 share in 1 bigger 2 quota Schedule B land by conferring plaintiff over the more or less 4 quota Schedule B land and deliberate possession of plaintiff so and so. Here it's very clear. Here if your Lordship is, they are saying possession has been partition. Prayer for this partitioning of the property, Your Lordship, because they said no order partition. So if the prayer of partition is there, if it is partition, my share was there, it will be. So, Your Lordship, that's very clear, Your Lordship. So it is a clear case of partitioning of the, because the suit is for partitioning of the ancestral property and giving my share. That is Schedule B, Your Lordship. That is the issue, Your Lordship. Now, if Your Lordship, I take para 57 itself, Your Lordship. Issue number 6. Whether page 57, yeah, page 57.
What?
57, Your Lordship. There one line I just take it because the learned just has probably wrong premises that it's not a partition of ancestral property. Then issue number 6, whether the plaintiff has right title 1/3. From the averment of the pleadings of both sides, the admitted position of plaintiff and defendant are step brothers and father of defendant, namely Maheshwar Gogoi, was the son of late Mehuka Gogoi. The plaintiff number 3, in order to prove their case, has brought on record the testimony of PW1. PW1 is a plaintiff petition. This is a plaintiff number 1, Your Lordship. Has submitted that and support the contention of the plaintiff. In his clause, he admitted that they have mutated their name in the suit land in 2002. Their names are there. I've shown it. He also stated that old copy of Jamabandi, but he did not bring this to us. He further said PW1 had not submitted any document regarding a sale instrument of Dhaneshwar Gogoi regarding the suit land. So it's not necessary, Your Lordship. PW1 has himself admitted suit land was enjoyed and possessed by Maheshwar Borai Pyariman since 1952. When the property is not, possession doesn't mean that if it is a separate property of their own, that question is possible. Here is a permissive possession. It says he's possessing on my behalf also. So here this possession doesn't make any difference, Your Lordship. Maheshwar Pyariman since He also stated his father was expired in 1991. From 1952 till the date of his father, plaintiff has deceased father had not taken any steps for the suit land. So, if the suit land is an schedule A land, so what steps I have to take? It's a partition. Either it's partition, it's not partition. Then PW has been, Dhaneshwar was not the father of the Maheshwar, the real father of so-and-so. PWT has stated in the suit was, land was possessed by Dharmeshwar Barua. He had three, Dharmeshwar is father of the main person. He had three sons, namely Maheshwar Gogoi, Ramakanta Barua and Pyari Mohan Barua. Dharmeshwar Maheshwar Barua. But your lordship, Maheshwar Gogoi is not a son, I think, no? No, Maheshwar Gogoi is not his son. Maheshwar Gogoi is the stepson of Dharmeshwar Barua, your lordship, because Maheshwar Barua, your lordship, Ramakanta Barua is a plaintiff's father, and Pyari Mohan Barua is the other brother, which was contradicted by PW1. They had inherited a father from PW so and so. So here, where is the question of contradiction, your lordship? The properties are clear. In his clause, PW submitted he did not know who has purchased the suit land. He admitted Ramakanta Barua has left the suit land after 1 year, and Ramakanta Barua, which is approximately 60 years. He further stated, my lord has got page number. He further said at the time Ramakanta Barua's marriage, that is my father, your lordship, Pyari Mohan Barua and are living a joint family. It is also admitted, your lordship. If it is joint family, after leaving Ramakanta Barua, Pyari Mohan Barua was living in the suit land, and after the death of Pyari Mohan, his family was living there. Here I may pause for a moment, your lordship. It is not their case also that the property has been partitioned, your lordship. It is not the case of the appellants also that this property has been partitioned also. They are saying abandoning the claim only on those things. Family. He further said there was an oral partition between Pyari Mohan Barua and Ramakanta and defender as enjoyed the suit land. So this oral partition they are relying. If the oral partition is not, the property remains as it is. Then PW3, people Lord Mondal of the theory in his evidence stated in Exhibit 5, which I have shown you given, there are 7 pattadas. They include our name also, your lordship. The serial number 1 is Vinod Barua. Serial number 2 is Dighola, it should be Dighola Barua is Ramakanta Barua, my father. This and Pyari Mohan is the other brother. Serial number 4, 5, 6 are Rupeshwar Gogoi, Uttam Gogoi, and Tankeshwar. This is defender number 1 to 5, your lordship. The total land measuring in the dark number patta is 6 because 1. So here, your lordship, it is not saying that it's scheduled land. It is total. It is in the dark. It may have a bigger land here, sir. So we are not concerned with 6 bigas. We are concerned with 4 bigas and not land here. The portion of land has not been mentioned there. The 7 names were inserted at the time of settlement. On 132, the names of the plaintiffs were inserted. DW2 also stated long back the plaintiff is late Ramakanta Barua, that's my father, had gave up his share of the suit land in favor of younger by Pyari Mohan. So, your lordship, it is not partition. I am not. How can I? There are contradictions are there. They said it was partition, giving no share to me. Here they are saying I have relinquished my share in favor of the. Which one to be believed here? All factual contradictions are there. Apparently, from the pleading itself and it is clear that plaintiff do not have possession over the suit land. The plaintiff have share land on the suit land, but the plaintiff side has failed to prove that suit land was owned and possessed by late Dhaneshwar Barua. Your lordship, they have said property has come. Dhaneshwar Barua is a grandfather of this petitioner plaintiff, your lordship. Now they are saying it is not because if you see the family tree, then how can the property? What they are trying to show that defendant number 1 to 5 has purchased some property, and they said it is not. I'm not saying on that, but they are not saying on 4 bigas and that a scheduled land. It is not the case that Dhaneshwar Barua is not the owner of scheduled land at that time, your lord. It is not the case. Plaintiff has also put that said Dhaneshwar Barua, namely Maheshwar Gogoi, Ramakanta Barua is my father, yes, sir, and Pyari Mohan has agreed equally to divide the suit land at 1/3 share in total suit land, as PW1 himself admitted in cross-examination. Late Maheshwar Gogoi was the son of Mehuka Gogoi. DW1, your lordship will see that contradiction everywhere, your lordship. If you lordship here again, it is partition equally divided.
Then in his clause, late Maheshwar Goy was the son of Mehuka. DW1 in his evidence stated Exhibit 5. It's the Jamabandi book of 1930 revenue book, so and so. Exhibit 5, the Jamabandi of Patta number 92 years. This is all Patta number here that which I told you about your lordship also. There was only one dark number in the state. In the state dark, there are total of 6 because 8 less. It can remain. It's a big parcel of land. Maheshwar Goy son of Mehuka was the original Patta serial number 8. As per note dated 28 for the state Jamabandi, land measuring 3 katta 18 less was muted in the name of Maheshwar Goy by way of purchase from Ghana. So it may be possible, but question is this: if this land is taken out 6 because the remaining 4 because remains your lordship. There is no overlapping of the land also. Exhibit 6, again I have shown that exhibit is the Sitta book of Jamabandi identified with table 6. Here our names are also there. Exhibit 5 and exhibit our names are also there. Exhibit G1 is Sitta of dark number 258 of revenue village of Nirga. The dark number 250 is covered by dark number 275 now. Total land is said that 6 bigger, 1 lesser. Exhibit H is a draft Jamabandi village so and so and so and so. As per draft Jamabandi, old dark number 258 is converted to dark number 275. DW stated in another note dated 13/11/46. The Jamabandi, it is there in the record 30 exhibited. Jamabandi reflect as per orders and the state Jamabandi. Nate Maheshwar Dighola is if you actually page 6 around with Dighola is my grandfather here. Here they used the word my pet name at the it is Ramakanta Burwai. And Pyari and Sorula has expired. He predeceased everyone here. There are 4 sons actually, 3 sons. He expired. So Dighala is myself here, my grandfather. Had been mutated by way of purchase by possession in Ghana. So that means according to them, I also possess some land there also. Purchase land. Therefore, it is clearly as a plaintiff late father has purchased land. It was clearly as a plaintiff's late father has purchased the land same dark. That means I have purchased the land also from the same dark, your lordship. From the evidence of the plaintiff and the defendant as discussed, I find evidence of defendant more probable. In view of the evidence, I am not considered view that people lies in favor of the. Therefore, how this conclusion arrived, your lordship? All are contrary. How the probability? See, your lordship, here it should be on evidence, not probabilities. If your lordship, the trial court has decided, she has decided on preponderance of probability also. How can the suit is not decided on preponderance of probability? It has to decide on basis. The evidence are contradictory. So this clearly shows this is incorrect, your lordship. Then how this has been dealt with the appellate court, and I go to that, your lordship. Issue number 6, your lordship, page 104, your lordship. My lord has got it. Issue number is whether right title into one para 20. The issue number 6, which is framed over the right title and interest of to the extent of 1/3 portion of the suit land and was decided negative and against the plaintiff. The learned trial court decides the issue on the basis of principle of probability of probability. This is very important. How can she probably finding in favor of defendant? That means there is no evidence. This is a subjective view, your lordship. Hence, it is required to be gone through the findings of the learned trial court. It is also required to examine the learned trial court took notice of to all documents submitted by either party to the suit or not. This is also important. Whether she has any. It is seen that the plaintiff appellant filed the case in seeking 1/3 portion of suit land, which was amicably portioned with the presence of the defendant and the present defendant. However, to decide the right title and interest over the suit land, it is required to determine main source of right interest of the parties. From the pleadings, it is found the suit land was an ancestral as claimed by the plaintiff. Here, the trial court has it's not an ancestral property, she has said, from nowhere, your lordship. Because in that, I showed that, your lordship. It is found that the suit land was an ancestral property as claimed by the plaintiff. On the other hand, the defendant denied the claim of the and claimed that the suit land was purchased land by the father of the defendant and not the ancestral. Hence, to this aspect, it is required to go through the materials of the case record to assign if the property was ancestral property and purchased property of the father of the plaintiff and the defendant. The learned trial court found that the plaintiffs and the defendants were step brothers. The father of the plaintiff was one late Ramakanta Borua, and the father of the defendant was late Pyari Mohan Borua. Ramakanta Borua is my father, Your Lordship. Both Ramakanta Borua and Pyari was the son of one Dhaneshwar Borua. Father of defendant was one Mohesh Gogoi, and he was the son of Mohuka Gogoi. The learned tried to prove the view that of evidence of PW when he admitted that he did not file any instrument concerning right and interest of Dhaneshwar Borua on the suit land. That because he said no document has been filed by that Dhaneshwar Borua is the owner of the property. It has not been denied. They have not denied that Dhaneshwar Borua is not the owner of the ancestral property, ancestral land. Because they are claiming they are share from them as a heir of this thing. How can they be contrary? At the same time, you cannot say that he's not the owner of the land. Or my grandfather is not the owner. How can I, if my grandfather is not the owner of the land, how can I claim share of the ancestral property? No one can do that, Your Lordship. Defender was the learned took the view evidence of wherein he admitted that he did not file any instrument concerning right title in the Dhaneshwar Borua on the suit land. Dhaneshwar was my grandfather. The PW1 also admitted in his cross agreement that he did not have any knowledge who had purchased the suit land. Because he cannot admit because his grandfather is who has purchased when he don't know. The learned trial court in paragraph 46 in a judgment found that father of late has purchased the suit land. This because here the appellate court has dealt specifically para by para this thing of the trial court judgment. Has purchased the suit land jointly, which was admitted by defendant in his pleading and evidence. This was ignored by the trial court, Your Lordship. But Ramakanta Borua gave up his share to years younger late Pyari Mohan. The learned trial court also examined one independent official with relevant record in respect of suit land. The court examined Exhibit 5, Your Lordship, wherein she found 7 members of Patra, including father's name, the plaintiff Ramakanta Diva. I showed you, Your Lordship, that column, that is Exhibit 5. Now, names are there. However, exhibit a total land was 6 bigger, 1 lesser, but in the witness could not ascertain the individual of each Patra. I also have exhibited and found that the names of present plaintiff were entered in the Jamabandi in such a way the record of rights suggested the names of the plaintiff have been recorded as Pattadas. The decision of trial court discarding the right and over the suit land is found unjustifiable. It is very important. The learned trial court viewed the reference to the pleadings and evidence of the plaintiff that the predecessor of the plaintiff gave up his share to the predecessor of defendant number 6 to 8, and they were in possession of the suit land over for more than 12 years. The predecessor of the plaintiff during his life did not file any case against the defendant over the suit land. During the trial, the learned court scrutinized the Jamabandi of suit land, which was marked as Exhibit F. In Exhibit F, this is a document, they are found to be only 1 Dagna to total land with 6 bigger 8 lesser. In the said Patta, name of late Mahesar was mentioned as the original Patta having land of 3 Katha 18 lesser by purchase of a Ghana. So, Your Lordship, this land may be not correct because the parcel of the is much bigger, Your Lordship. The learned court perused Exhibit 6, which was the Chitta book of the Jamabandi of Dag number and the identified PW3. He also perused the Chitta and Dag number 258, which was subsequently converted Dag number 217. In para 46 of the judgment, he specifically said of the judgment trial, it is found that the learned trial court took the view of a note dated 13/11/1946, inserted in the Jamabandi. It is found that there in that note that the 17/7/1946 names of Maheshwar Gogoi, Dighola is my grandfather, Your Lordship, Pyari Mohan and Saurabha has been mutated by way of purchase in relation to Ghana. So here, even the purchase land also the names are there. So it is in view of that, the learned trial court affirmed that the father of the plaintiff purchased the land over the same Dag. Therefore, when the learned trial court itself affirmed the right of the plaintiff on scrutiny of evidence record, determining the issue against the plaintiff is indeed wrong and need to interfere. Your Lordship, the court has inferred that I have purchased and I am not entitled to the land also. Totally contradiction, Your Lordship. The learned trial viewed that the predecessor relinquished his right over the suit land from which he has got it. There is no statement obtained by me. There is no document or anything. Only they are saying that I have relinquished the deed. Mere oral statement of relinquishment won't suffice, Your Lordship. He left the land, suit land, and shifted his residence some other. The learned court denied the right title interest over the suit land of the on the principle of adverse possession. So The trial court has received here and he brought the concept of adverse position. The learned court appearing for the plaintiff appellant submitted that where the defendant representative claims the right over the suit land on adverse position, the right title interest of plaintiff appellant cannot be denied, and it is an admission by the defendant. In paragraph number 52 of the impugned judgment, the learned court has admittedly found that the suit land was not owned and possessed by grandfather of the defendant, respondent, Dhaneshwar Bora, but owned by Maheshwar Goy, Ramakanta Bora, Pyarimon jointly. So here another paradox came. Here said the grandfather was not the owner, but it is jointly owned by Maheshwar Goy, Ramakant Bora is myself, my father, and Pyarimon Bora. So trial court is totally topsy-turvy findings they are coming to. Where the learned trial court from where own finding found that the predecessor of the plaintiff's appellant was the joint owner of suit land. The joint owner is there with the defendant and a pro forma defendant. In such circumstances, denial of right title of plaintiff is absurd and not need to be rectified. The names of the plaintiff appear in the Jamamand with the names of the defendant. Hence, relying on the evidence of both the parties and the documents submitted thereof, it is of the view that the plaintiff has right title share of the state as one third. So it is very clear, Your Lordship. Then I come to issue number 7, Your Lordship. Yes. Then I come to Your Lordship. Issue number 7. Yeah. Page 61 of the trial court. I just go by issue wise. Page 61, Your Lordship. Issue number 7. Whether the defendants have right title in the entire schedule land, including schedule B land. DW1 Uttam Gogoi, in his evidence and in amended stated that Dhaneshwar Barua had 3 sons, namely Ramakanta Barua, this is my father, Pyari Mohan Barua and Sarala Barua. His deceased father was the son of Mehuka Gogoi. After the second marriage of his grandmother with Dhaneshwar Barua, he gave birth to 3 sons, Ramakanta Barua, L.S. Digala, Pyari Mohan and Sarala Barua. His grandmother brought his father and kept him with the family of the Dhaneshwar Barua. The actual fact was told him after filing of the written statement along with other defendants by an elderly person, Tikun Gogoi. DW1 stated that according to the old revenue record, his father Maheshwar Gogoi, son Mehuka, independently purchased a land measuring 3 kata 18 lessa under dark number, and his father's name was also mentioned in the revenue record. Again, another plot of land measuring 2 bighas 1 kata 2 lessas of land under dark number was jointly purchased by the father Maheshwar Gogoi along with Ramakanta Bora, Dighola, Pyarimon and Sarala. Therefore, the entitlement of DW1 and defendant number 2 to 5 was 1/4 share, which is equivalent to kata so and so. And father said that his father also purchased land measuring so and so, the village so and so. So here he has admitted that shares are there. Then if you should see on the death of Maheshwar Gogoi, his legal heirs is important. And successors are entitled to land measuring 3 kata 80 plus 1/4 bigger so and so, total land 1 bigger so and so, and let Maheshwar was independent. So here the defendant himself admitted that I am entitled to share the land. He said the amount purchased by that is separate, and from the ancestral property, he is entitled to a portion of the share, 1/4. So he is admitting here that he is entitled to share that. It is being confused. So he may have purchased. I am not concerned. I am concerned with scheduled land, the 4 bigger land. For here, he is claiming that, Your Lordship. Late Maheshwar Gogoi also independently purchased land measured 2 kata 1 lessa under dark number 7. We are not concerned of this land, Your Lordship. That is his purchase. The said dark number 2C is now included in present dark number. The remaining land of measuring 4 kata said that may have acquired. Your Lordship, may have acquired jointly by late so and so. And how can it be made? It should be confirmed here, sir. How can may have acquired? The expression Your Lordship, may have acquired jointly by late Maheshwar and predecessor of the plaintiff, as well defendant of 6, namely Ramakanta Bora and Pyarimon. So from here again, it is again say it's a joint property, Your Lordship, not of one individual. That's contradiction going ahead, because here it is Your Lordship say that I am also joint owner of the property. And at the same, they are disowning me also. DW1, his father stated the name of Maheshwar has been mutated in the old revenue record to a date of today, being purchased by land by Ghana so and so. Therefore, defendant number 1 to 5 and research so and so, then measuring and research. So, my letter has raised an objection that the appellate court did not consider this document 28 to 1941. This document. So, this document, revenue record 1941, which they have stated here, is referred here, Your Lordship. So, here it is my way, according to that document, we are also the landowner here also. Maheshwar has been mutated in the name, Your Lordship. 41 is there. 46, 47, this is 41 document, 40 also I believe. So, therefore, defendant number 1 are entitled to 2 kathas, 1 lesser, plus 1/3 remaining of 4 kathas of total land, measuring so and so, so and so. Admit both defendant are just late Maheshwar has total entitlement of land of 2 bighas 0 under aforesaid 2 dal. TW1 submitted defendant number 1 to 5 were not occupying any share of the land as late Ramakanta Borua and late Pyari Mohan Borua. Rather, the heirs of late Pyari Mohan Borua, that is defendant number 6 to, were enjoying some portion of belonging to share of defendant number 1 to 5 as per mutual understanding. That is their outlook. DW1 stated that his father's name was recorded in the revenue records purchase of 28 against the original partner Ghana. Therefore, total entitlement defendant number 1 to 5, 3 kathas so and so under dark number so and so. Remaining suit land has been inherited by plaintiffs and defendant number 6. So here also they are admitting that it's an ancestral property. It has inherited by these people. Yeah, inherited by plaintiffs are also there. DW1 further said there was an oral partition of the suit land long by among the parties. Now, here I may pose here the defendant number 1, as he is stating that what is an oral partition. My learned father say, the court has said, I am not able to prove the oral partition. Here, this is very important also. DW1 further said there was an oral partition of suit land long back among the parties. This is very important. As per oral partition, DW1 and this is took separate position of the land as per entered and have been living separately by consideration without any having dispute among the co-partners. So here, this is totally this. The question of here, the defendant one has accept the oral partition here. Now the question is that the learned judge has said, I am not able to prove the oral partition.
I say mistake. Both sides cannot but saying a date in the first week of August, September. September.
For 18.
18, my lord. It may be on my lord. Second. 9. Can it be 9?
In item number 14 as well, Your Lordship. We'll also take some time, item number 14, with the consent of the other side and for the respondent. There is some urgency in the end of August.
Item number 14.
14. 1 4.
So for the respondent.
And for the
30.
end of August, Your Lordship. First week of September.
I was on page 63, Your Lord. Page 63. Page 63. DW1 submitted that defendant number 1 to 5 were not occupying any share of land, heirs of late Ramakanta Borua and late Pyari Mohan Borua. That means here is a clear admission that I have share in that plot. Rather, the heirs of late Pyari Mohan Borua, that is defendant 6 to 8, were enjoying some portion of land belonging to share of defendant 1 as per mutual understanding. DW1 also stated his father's name was recorded in the revenue record as purchaser on 28 to 41 against original partner Ghanenko. The total entitlement of land of the DW was 3 kathas, 7.66 lestas under DAG number 274 and 27. Remaining suit land has been inherited by the plaintiffs and defendant 6 to 8. This is important. DW has further stated that an oral partition of the suit land long back amongst the parties. Well, here I was posing your lordship because the trial court has said there is no proof of oral partition. Now DW1 himself admits that there is an oral partition. As per oral partition, DW1 and his deceased brother took separate possession of land and as per their entitlement and has been living separately by constructing residence without having a dispute among the co-partners since long. So far, the share of the prisoner of the plaintiff, here again share of plaintiff, and defendant 6 to. So there was an oral settlement between them, and both of them have been enjoying separate position. In his cross-examination, DW1 stated that at first they filed written statement and counterclaim and had taken the plea of adverse position. Thereafter, this is important. Thereafter, DW1 and defendant 2 to 5 had filed an amended written statement, and in the amended written, defendant 1 to 5 has not taken the plea of adverse position. This is important. I pointed out at the beginning. Plaintiff's land is covered by PP number 7 and defendant himself is also partner serial number. So I have admitted that I am in the partner number. DW2 Shankar Singh in his evidence stated suit land measuring 3 bighas covered by DAG number 27 and PP patta 1 bigha katha and so covered by DAG number 7 undergo is situated in front of his house. The defendant number 1 along with his family as well as the family members of late Pyari Mohan Borua had possessed the entire land, suit land. Defendant number 1 Uttam Gogoi was the son of Maheshwar Gogoi and Maheshwar Gogoi was the son of Mukulme. The predecessor of the plaintiff, namely Ramakanta Borua and the predecessor of defendant number were son of late Dhaneshwar Borua. He further stated that long back plaintiff prisoner late Ramakanta had given up his share of the suit land in favor of the younger brother Pyari Mohan and settled about half a kilometer from the suit land. This is important. Here, they say here two things are important. Here, whether I have a share in the land that is been established, your lordship, ancestral property, they are claiming that I have given the land to him. So there is no relinquishment that cannot be taken into account, your lordship. Mere statement. In his cross-examination, DAW deposed that a suit was an ancestral of the plaintiff and defendant. It's very important. He has admitted it's an ancestral property. Then DW3 Buddheswar Gogoi, in his evidence stated that he knew both the plaintiffs and along with the suit land. The suit land was possessed by the heirs of Maheshwar Gogoi, that is defendant 1 to, and the heirs of Pyari were the defendants since last 30 years. The father and husband of plaintiffs have left the suit land 50 years ago and settled half a kilometer from the suit land. The father of, here you also, if I take some place somewhere, it doesn't mean I am abandoning the land. They are taking, since I have gone 6 kilometers, half a kilometer that side, I have constructed a house. It doesn't mean I have abandoned my share in the ancestral property. There is no document to that effect. The father of Maheshwar Gogoi, Ramakanta Borua, Ramakanta and Pyari Mohan were not the same, rather mother of the same. DW3 father stated he had knowledge about the suit land was purchased by Maheshwar Gogoi, Ramakanta Borua. Here again, suit land again he purchased. It's all contradiction. Ramakanta, it has been purchased. Here he says, Ramakanta Borua is my father, your lordship. And Pyari Mohan, but he did not know about the share. He also stated Maheshwar Gogoi expired in so and so. When Ramakanta Borua left the suit land, he had relinquished his share and gave it to Pyari Mohan. They say again, he how can a stranger knows his relinquishment is? He doesn't know anything. Thereafter, Pyari Mohan has enjoyed and possessed his share, and also Ramakanta Borua said in the suit land till the death of Pyari Mohan. Here it is saying that defendant number 6 to 8 is being possessing the suit land and they are enjoying the thing. There is no argument. DW have further stated after leaving from the suit land, Ramakanta Borua had neither come to claim the suit land nor the plaintiff had come to the suit land to claim their share. This clearly shows it is an ancestral property and it's a partition. They said, I didn't claim my share, I relinquished it. If it is a separate property purchased by defendant 1 to 5, they say, then there is a question of having my share there. So this is totally contradiction, your lordship. Then DW4 Dipjyoti Boro has deposed in his evidence that a predecessor of Ramakanta Boro, my father, was the elder brother of his father. DW4 and his co-heir has been possessing a share of the plaintiff since lifetime of his father for more than 30 years. Someone says 50 years, someone says 30 years, someone says 60 years. Number of years are different here. Here, this gentleman is saying 30 years. He saying during his more than 30 years, he says 60 years. One person says 50 years. So all years, there's no definite date when it was there. More than 30 years, and adversary knowledge of the plaintiff. How can it be adversary knowledge of? He is trying to prove this adverse position. The plaintiff father left the suit land long years back and settled half a kilometer away from the suit land. During the period, DW4 and his co-heir had made substantially on the share of his father and as well as the share of the plaintiff's father. So this is very important. My share is there. He admitted that suit land was not originally owned and possessed by his grandfather Dhaneshwar Bora. Rather, part of the suit was independently owned by Maheshwar Goel, Ramakanta Bora and Pyare. That means here again the next twist of the case comes. Here says Ramakanta Bora is my. I have also purchased with them. Then you have drawing attention of this court to the evidence of the DW5, Navajit Kolria RKV branch, DC office Sonitpur, in his evidence stated that Exhibit F, which my friend is relying, is the Jamabandi book of 1930 of Revenue Village Moja Gore. Exhibit F1 is a Jamabandi Patta of Namato. There was only one dak, 258 in the state Patta. In the state Taka, there was total 6 biga 8 lessa of land. How was this 4 biga and this thing? Maheshwar Goel son Menuka Goel the original Patta. As per note, there was 28 for the same land measuring 3 kata 18 lessa was muted named Maheshwar by way of purchase from. Here they have said we have purchased. Here again is in his name. The paragraph was contradicting. That apart the land documents submitted by plaintiffs by me reveal the name of the if are duly muted in the records of in respect of suit land. I am not saying that they are not the owner of the records. There is no. I am not disputing that they are not the co-share of the joint property or ancestral property. The exhibit clearly reveals that the name of the defendants were duly muted in respect of portion of the suit land. That portion of the suit land means it is they are not entirely. There is mention of the name of Maheshwar Goel in contention. Maheshwar Goel in contention of exhibit which are duly proved by PW3, the last month of and DW5. RK branch DC office only had submitted a revenue paying receipt of only year of 2012, but the other receipts were not submitted in the absence of other issues. It cannot be revenue. Your Lordship, question of paying, giving, exhibiting revenue receipt doesn't confer you any ownership of this thing. Anyone can pay revenue. They said we have been paid 78 till today. Whatever prior to that. If that is so, I can if the 78, if the receipt processing of 78 to 12, whatever they said they have been possessing since long back. 60 years back. So where is the revenue receipt for those? So these are paying revenue doesn't give title, neither takes away title nor gives the. It is for the purpose of collection of revenue. These things are done. Your Lordship. Revenue receipt. It appears from the cannot be taken as revenue regular paid. He said I cannot. Anyone can pay the revenue. It's a joint property. He said I have not paid the revenue, so I am not entitled. They are paying it for 78 or not, that is their thing. It appears from the document that the defendant side has explained the revenue paying receipt from the year 1978 to 20, which clearly establishes the fact that defendants have been paying the land revenue. Payment of land revenue can be done. From the foregoing discussion of evidence and the reasons, it transpires that documents as submitted by the plaintiff reveals the name of defendant is duly muted in the records of right in respect of suit property and legalized of the and late period. Exhibit also reveals the same. In the evidence of PW3 and DW, clarifies in the word in the land record of PP number so and so, village so and so, Korea, there is mention of the name of the defendant with the plaintiff. This is very important. He said, my name is also there. How can we there? Since there is no, I could not proceed as revenue receipt, so I am not. I cannot claim any right on that. In result, the court of the consider the defendant have a right title interest in the suit land. So, on the basis of revenue receipt, she has decided this thing. See, that cannot be done. Now, I take the Lordship to the finding by the appellate court, Your Lordship. This issue number. Issue number 7. Please. Your Lordship, issue number 7, page 108, where I had the appellate court done. Page 108. Whether the defendants have right title of the entire issue, including B schedule land. That is the issue number 6 is framed in the form that whether defendants have a right title in the Schedule A land, including the Schedule B land. Your Lordship, Schedule B land is a part of Schedule A land. It is seen that the issue is interrelated to previous issue, and that is in issue number 6. As per pleadings of the parties, the A schedule land comprises of 4 bighas, 1 katha, 1 lesser, which is the joint property of both. My land is this only. I am not bothered 6 bighas and this. Mine is 4 bigha, 1 katha, 1 lesser of land. The B schedule land covering 1 bigha, 2 katha is the suit land, which is situated in the middle of part of A schedule land. In the deciding the issue, the learned can only scrutinize the evidence of DW1. This is very important. He has only taken the learned court on scrutiny of the evidence of documents mentioned in the judgment, and the father of defendant Maheshwar Gogoi was the son of Mehuka Gogoi. His father Maheshwar Gogoi purchased the land within 3 katha 18 lesser and the dark number, and his father's name was duly mutated. So this we are not concerned with this land here. The mixing of the land. From the evidence of DW1 defendant, it was also admitted, found that another plot of land measuring 2 bigha, about 2 bigha 1 katha was purchased by his father Maheshwar Gogoi. Ramakanta Bora is my father, alias Dighola. Pyari Mohan was Saurabh Bora. All the 4 brothers purchased another plot of land. It is further found in evidence of defendant, this is father of defendant was also purchased another land, another plot of land measuring 2 bighas, 1 lesser, new dark number, papa and so and so. So here these are all different parcels of land. It's not connected to the schedule land. So the trial court has mixed up all the issue, and on the basis of these documents, she has given title of this to them. Remaining land measuring 4 katha purchased so and so, and jointly purchased by father of Ramakanta. If we rely the evidence of the defendant, and the documents he submitted, we fairly found that the father of defendant number 1, late Maheshwar, purchased 3 katha 18 lesser under dark number so and so. And the land measuring 2 katha and the lesser. So yeah, it is there. Now this is very important. On calculation, he was the owner of total 1 bigha 90 lesser. That is his father, Maheshwar Gogoi, which is situated in the part of A schedule land. However, it is also admitted, found that the father of the defendant, late Maheshwar Gogoi, father of plaintiff, late Ramakanta Bora Digola, and late Saurabh Bora purchased 2 bighas and 1 katha of land under dark number 275, measuring 2 katha 1 lesser of land. It is found in the evidence on record that the father of the defendant and the predecessor of the plaintiff jointly purchased remaining 4 kathas under dark number. The learned court also found in evidence that both the dark number, 275, 27 are situated adjacent, and the plaintiffs and the defendant are joint owner of the land. Here she has admitted as joint owners. We are the joint owners here. Learned trial court found the evidence that we are joint owners also. She said we are not of the land to the extent of 2 bigha 1 katha so and so lesser dark number, and his total measure 3 bigha 2 katha. So for other measure 3 katha 1 is concerned, the this is father and the defendant number Maheshwar Gogoi was the exclusive owner. Now the reasoning given by the trial court or the appellate court on scrutiny of evidence of DW2. This is important. It was admittedly found that land measuring 3 bigha under dark number 270, PP and land measuring 1 bigha 1 and dark number PP on the suit land was situated in front of his house. The defendant and the family members of late Pyari Mohan Borua were possessing the land peacefully. So far as the predecessor of plaintiff is concerned, the learned court found the evidence that the predecessor of plaintiff, late Ramakant, shifted his house from the suit land, leaving his part to his younger part, Pyari Mohan Borua. However, in the evidence of DWT is admittedly found that by learned court that the suit land was ancestral property. DW, he said ancestral. I told in that portion also, Your Honor, of the defense and the plaintiff. All other who examined as DW3 and DW also admitted the version of DW1 and DW2. The learned court found the names of defendant number, defendant and the plaintiff in the land record. That I've shown the exhibit 5, exhibit 6. But so far as the share in the concern after technical, it is found that the predecessor of defendant 1, 2, 3, Maheshwar Gogoi was exclusive on the land measuring 3 katha 18 lesser in both dark numbers, and co-owner to land measure 3 katha, so both dark number with the predecessor of the plaintiff, late Ramakanta predecessor. So here 3 types of land is there. One, solely owned by Maheshwar Gogoi. Second, for They're jointly owned by plaintiff's father, Maheshwar Gogoi, and Pyari Mohan Gogoi. Then another part is the ancestral property. So 3 different parcels of land, Your Honor. Here it's clear. The issue, though rightly decided in favor of the defendant, but the defendant have the right title interest over a scheduled land, but the right title of land cannot be denied for admission of development. So here, you cannot deny the right of plaintiff. You no doubt they have the right. I'm not saying they don't have the right, but you cannot deny that. That is what the appellate court has held. So this now I come to the Your Lordship. This is one another. Then I compare. Some additional issues are also framed, Your Lordship. If Your Lordship takes to page 73, Your Lordship, trial court order. Whether the suit land is ancestral property of plaintiff and the defendant. PW, my lord as well, page 73. PW3 in his evidence stated Exhibit 5 is the Jamabandi of PP number. From it showed that plaintiff name was inserted as Pattadar. This is important. In Exhibit 5, it also reflected defendant Utta Gogoi, father's name Maheshwar Gogoi, and Tankeshwar Gogoi, Suman Gogoi, father's name Tankeshwar Gogoi, Rupeshwar were also entered. The name of Pyari Mohan Borua was also erased from the Damabani, and his place was Bolen Borua, Dipjyoti Borua, name was inside. In the same revenue village, the name of Rupeshwar Borua, Uttam Borua, and Tankeshwar was reflected. Here it's simple. After erasing the name Ramakantas Borua's name, that is my father. His wife and says Pramila Borua, Jotin Borua, Tandan Borua, were names of it. These are the plaintiffs, Your Lord. Exhibit 6 is a relevant document of Mayadi Patti, Exhibit Chittabago Jamavani Dag number, and the original Pattas were Maheshwar, Pyari Mohan, Vinodram Borua. Exhibit 6 is the Chitta book of Dag number, the names of Rupeshwar Borua, Uttam Borua, Tankeshwar, and Sri Pramila Borua is a wife of Pyari Ramakanta Borua. Very reflect. Father's names of Rupeshwar Borua, Uttam Borua, Tankeshwar Borua are not seen. Ramakanta was a wife, Sri Pramila Borua is my mother, Your Lordship. Sons, namely Jatin Borua, Chandan Borua, and Provin Borua names were mutated. The name of Bolen Borua, Dipjyoti Borua, Tankeshwar Borua was instead. Exhibit 8, Chitta Dag number so and so are the computer's copy of Patta numbers. In Exhibit 5, there are 7 Pattadas. The serial, this is important. Exhibit 7. The serial number 1 name is Vinod Borua. Serial number 2 and 3 is Sri Diganto Gogoi and Pyari Mohan Borua. Serial number 4, 5, 6 are Rupeshwar Gogoi, Uttam Gogoi, Tankeshwar. The total land measuring under Dag numbers where Patta numbers is 6 biga 1 lakh. So this letter total the 2 Dag. The share of land had not been mentioned there. The 7 names were inserted at the time of settlement. On 1/3/2009, names of plaintiffs were inserted because he expired as the names of sons have been. In Exhibit 6, the main Pattadas were Rupeshwar Borua, Uttam Borua, Tankeshwar Borua, and Ramakanta Borua. Ramakanta Borua is my father, Your Lordship, and Pyari Mohan Borua. The total land on the Dag number was 1 biga, 1 katha, 1 less. Exhibit is a Chitta book on the Dag numbers with names of Rupeshwar Borua, Uttam Borua, Tankeshwar, and Exhibit is cadastral map of revenue village, so and so. So the main Patta music by your purchase and so and so. The total area of land in Dag number 340 was so and 2 kathas and 1 less. As per, if I last skip that portion, I have come to para 71, down below. These are descriptions of land. Your From the foregoing discussion, evidence and regions transferred that Maheshwar Gogoi has purchased land of 3 katha 1 lesser and mutated in the name of Maheshwar by way of purchase and Gora and Maheshwar Gogoi to the stage of. As per order the 17th, the judge Maheshwar Gogoi, Dighola is my father, Your Lordship. Pyari and Sarula had been mutated by way of purchase and possession in place of Gora. Therefore, it can be said the suit land is not ancestral. Your Lordship, this is a different land which he is referring. This is the land which he is referring is a totally different land. The other land purchased by anything. So he has mixed up the ancestral with the distinct. Because if Your Lordship see the description here, this is separate land. This is not the ancestral land. 4 biga there. Here it is said that way. So therefore, it can be suit land was not an ancestral. How this finding is like that? Those lands are not ancestral. I am not saying that. But question is, you cannot say schedule is not ancestral land. Now I come to the findings of the appellate court on this issue. Your Lordship, page 117, Your Lordship. Page 117. Issue number 12, Your Lordship. The issue number 12 is framed to ascertain whether the suit land is ancestral property of the plaintiff and the defendant and the learned trial court by the learned court. In deciding the issue, the learned court has gone through the oral evidence as well as document submitted by the. In conclusion, the learned trial court has held that father of defendant number 125, Maheshwar Gogoi, purchased suit land from one Ghanakanta. Suit land, he didn't purchase the suit land, Your Lordship. The learned trial court has also perused the entry of Jamabandi 28/4/1941, found that his names are in Jamabandi, and in view of the entry of the learned trial court, the view that suit land was not answered for the plaintiff and the defendant. I have perused the evidence. This point. I have perused the evidence and scrutiny the learned court once and again. The learned court just below para 71, wherein she found that late Moisar was the owner of suit land by purchase of Ghanakanta and Naresh Narendra. Father mentioned the state Jamabandi name of the deceased father of the plaintiff Ramakanto and the neighbors. So even that names of the petitioner father is also there, the respondent's father. Whether the father, the name of father of plaintiff Ramakanta Borua and the name of the deceased father of defendant appear even in the same entry. Again, exhibit 5 being Jamamandi PP number which was submitted by PW3. The learned court found the name of the father of defendant with the name of the father of the plaintiff and the name of the present plaintiff also available in the entry. Further, the learned trial court found that the names of the plaintiff were inserted in the Jamabandi White Order 1/3/2002. As per note, exhibit 3, the main patadar of the suit land as existing there. Rupeshwar Borua, Uttam Borua, Tonkeshwar, Ramakanta Borua is my father, and Pyari Bhanu. On discussion made in issue number 6, 7, and 8, just found that the father of defendant Maheshwar Gogoi purchased a land with 3 katha 18 lessa only. This is the. But so far the other land is concerned that this is father of the plaintiff, the defendant 1 to 5, and the father of defendant say were joint owners. These are the findings. There is no dispute in this aspect as the admitted that all the three others, namely late Ramakanta Bora, Pyariman Maheshwar, were the joint owners of the suit land. While it was determined by the learned trial court that three brothers are mentioned above the joint owners of suit land, in such determination of learned trial court in the issue found wrong, hence it is pertinent to interfere with the decision of learned court, and the issue is decided accordingly to the ancestral property of plaintiff defendant. Now, another additional issues that we made, those are important. Issue number 13, Your Lordship, that is page 77, trial court. Page 77. Whether the plaintiffs are entitled to separate possession to the extent of 1/3 share in the suit land. That's the issue. The trial court has said the plaintiff has already admitted that a defendant has possessed the suit land since 1952. From ready reference under section 27 of limitation I quoted about, excluded at that determination so and so. So the right itself gone with title seriously and not fairly remain. It is settled law that position is true. Here for the person adverse position. So how can she decide adverse position like just merely on the thing that I didn't say adverse position. Now next page is 74, Your Lordship, page 78. The person claiming adverse has to satisfy importantly adverse. He must be in actual possession of the land. The possession must be educated in continued publicity and to extent show that it is adverse to the owner. The possession must be open, notorious, actually. There must be intention to hold the property disposing the true owner. Here, Your Lordship, I pause for a moment. Here, one plea is that I have relinquished the share to that person. Pyari Bhavan, to Pyari Bhavan, defendant, father of defendant of 6 to 8. Another version is that I have shifted to some place, so I didn't. So question is, it has to be hostile to the true owner. You have to recognize that I am the true owner of the property, and hostile to that I am claiming, I am possessing the land. Then the question of adverse possession. How can a ancestral property, which according to them is not been divided, can have is a permissive possession? Because in an ancestral property, everyone's possession is not necessary. It's a joint ownership. So this is totally atrocious, Your Lordship. Then Your Lordship will see this para 75. On the adverse possession, the Honorable Court has so and so, they have relied on the judgment. This is totally misapplied here. 76, it says, para 76. In the instance of the plaintiff by adducing evidence has proved that defendant number 6 has been possessing us continuously, peacefully and until for more than 60 years and ever. So here it is 60 years, there 30 years. All the years are shifting. 30 years, 60 years are somewhere is 30 years, 60 years. So Your Lordship, he's saying, I have proved this case. He has to prove that case. Your Lordship says, plaintiff and defendant admitted suit land was meted in the name of pursuit land country of peaceful unlimited for more than 60 and adverse title to the true owner. Plaintiff and defendant admitted that suit land has meted in the name of Maheshwar Ramakanta Borua. Again, mutation is in my name also. So how can it be a Pyari Mohan Borua, the father of the defendant? The defendant in his by evidence also proved that they have been enjoying the suit land adverse to the title holder, and after making them known, such enjoyment against the interest. The reluctance on the part of the to contest the suit and the assert their right over the suit land, ever after knowing the law, the defendant has claimed the title over suit land adverse to their own, implies the willful negligence on the part to protect the right of suit land. Such reluctance on the part of the plaintiff shows that they have accepted the hostility of the defendant towards their own interest. The intention of the defendants are adverse to the interest of the plaintiff and has been proved by the defendant to have been known factor. Where is the proof of the adverse possession? None of the criteria have been satisfied. Hence, therefore, the plaintiff is not a separate position to extend, hence the issue is decided in negative. Now, I take Your Lordship to the appellate court portion. If Your Lordship take page 113, 119, sorry, 119. Issue 119, yeah? Issue number 13 was framed by the learned trial to decide whether plaintiff was entered separate portion of extent of 133. The learned trial court decided the issue negative and against. I have gone through the discussion made in the issues wherein the learned trial court determined the issue based on principle of adverse possession. However, in deciding issue number 8, it was determined that the defendant side don't have a right title interest over B schedule land by right of adverse possession. The prime cause was that the defendant number 6 was the permissive possession. This is important. Permissive possession cannot be upon the B schedule land, and the right of the owner, right of other co-owner, that is the defendant 1 to 5, was also involved. Both the defendant number 1 to 5 and defendant 6 to 5, being the heirs of late Maheshwar Goel and Pyari Mohan Borua, were enjoying a possession equally over B schedule land. The adverse possession of B schedule land was claimed by defendant number 6 by a counter claim, but the deposition of a counter co-share of the possession defendant number was not claimed. Accordingly, the issue through decided in favor of the defendant by a trial court, but in the court found decision was wrong, and I was held that issue number 9 suit land as an ancestral property of issue number 9. It was held that plaintiff has right title interest over the suit land to extend 1/3 share of the duty defendant. Hence, I am the view the interference of decision of held position of so and so. Your Lordship, here even now I come to Your Lordship, the counter claim. As I have already stated, Your Lordship, the counter claim they are claiming it with respect to defendant numbers 6 to 8, Your Lordship. For the purpose of counter claim, Your Lordship, certain conditions has to be satisfied, Your Lordship. Here, if Your Lordship will see, first thing I said, no issue has been framed as a counter claim. If Your Lordship will see the page there, whether the defendant is entered for counter claim, there no issue has been framed. If I have shown it, Your Lordship, that is the page, the issue which has been framed by the trial court, Your Lordship. That is that page. That is page 52, 53, Your Lordship. If Your Lordship will say, only two issues regarding to counterclaim has been stated. Two is whether there is any cause of action for the counter and whether there is any cause of a counterclaim from 64 to this year. Anyway. Then four is whether counterclaim is barred by limitation. These are the two issues they have decided. But where is the question of whether they are entitled for counterclaim has to be there. When there is no issue, the question of counterclaim doesn't arise. Because your is fully aware that for any suit, issues have to be framed to be decided by a court. So here issues have not been framed. Where is the question of going for counterclaim, your lordship? So that is there, your lordship. Then I take your lordship to
The fact why
it is there. It is there. I've shown it here. It is here. It is recorded in the judgment. I'll show you. Yes, I told you. You could be just. It is there.
I was examining the record. It came to my notice while I was examining the record during the break. The written statement against the counterclaim is filed as an exhibit, that too unsigned, defendant's exhibit.
But here a court has said
taken into consideration. Exhibit A of the defendant is actually the counterclaim. That is also not signed. It is on record. Yes, sir.
It has been recorded also. It's a affidavit is filed. That is there. Trial court is it is there. I'll point out here. It is there. The trial court is recorded. The affidavit is filed against the counterclaim. It is there. Just trial court judgment. I just saw it. It is there. That is I'm finding. I just got it. It is there. Without being bad, I won't make a statement. I've seen it. Your Lordship, page 51. Page 51. Gist of defendant case, Your Lordship. Page 2, para 24. Against the counterclaim, the plaintiff submitted written statement denying the claim made by the defendant and the counterclaimant. The plaintiff brought the angle of trespass by the court. It is there, Your Lordship. The trial was recorded that. So I won't make a statement without seeing it. Because my learned friend raised another issue, Your Lordship. Because my learned friend has raised another issue. There is a partition matter, there is no preliminary decree. Under, he took the help of Order 20 Rule 18. Now, Your Lordship, Order 20 Rule, may I read for the convenience of Order 20 Rule 18? CPC. Order 20 Rule 18. Judgment. decree in a suit for partition of property or separate possession of share therein. Where the court passes a decree for partition for property or property for separate possession of a share therein, then if it is so far a decree relates to the estate assessed to the payment of revenue to the government, the decree shall declare the right of several parties' interest in the property, but shall direct such partition or separation to be made by the collector or any gazetted subordinate collector deputed by him in his behalf in accordance with such declaration of the provisional section. If this clause, if in so far as the decree relates to any other immovable property or movable, the court may, if the partition or separation cannot be conveniently made without further inquiry, pass a preliminary decree declaring the rights of several parties. That's so and so. So here is the court may. Now here, your lordship, the issue is the partition will be contested by them also by counterclaim. So how can a preliminary decree be passed at that instance without educating the entire issue? I got a judgment of the apex court, your lordship. Your lordship take this step. Para 8, your lordship. A preliminary decree declares the right of shares of a party to the partition. Once the shares have been declared and further inquiry still remains to be done for actually partition and placing the party in separate position or divided, then such inquiry shall be held and pursuant to the result of the further inquiry, final decree shall be passed. A preliminary is one which declares the rights and liabilities of the parties, leaving the actual result to be worked out in further process. Then, as a result of the further inquiries conducted pursuant to the preliminary decree, the rights of the parties are finally determined and a decree is passed in accordance with such determination, which is the final decree. The distinction between preliminary and final decree is the preliminary merely declares the right and shares of the parties and leaves room for some other further to be held and conduct pursuant to direction made in the preliminary decree, which inquiry have been conducted and the rights of the parties finally determined. The decree inquires are needed. Here, your lordship, here in this case, there is a decree already passed by trial court. It is an appellate stage. It's an appellate stage. So here the issue is not be this thing. Your lordship, the question here is, it is not necessary because when there is disputed decree, it is not necessary to file a preliminary decree, your lordship. Then if your lordship will, in the next para, in the case at hand, a perusal of the decree dated 13 to 17 and the contents of compromised application with 3 schedules of property annexed therein shows that the property was partitioned by metes and bounds. Not only the shares, but the property actually falling in the share of each of the 3 persons were actually defined and given to the party entirely. The decree dated 13 to 78 demarcates the properties forming part subject matter of the partition by metes and bounds. For all practical purpose, the decree dated 32 was a final decree. Under Order 20 rule, it is not necessary to pass a preliminary decree. This is very important. The court may pass a preliminary if it is required. If the right of the parties are finally determined and no further inquiry remains to be held for the purpose of completing the proceeding in partition, then there is nothing in law which prevents the court from passing a final in the way of, in the very first instance. Often such are the cases which are based on compromise. The present one is one such case. However, still one of the parties sought for a final decree being drawn up. The court and the parties acted under the misapprehension that a decree dated was a preliminary and therefore finally was needed to be drawn. As we have already stated, the final decree dated 25 is nothing but a reproduction of a schedule contained in the preliminary decree dated. The only difference is that the decree dated 24 is engrossed and transferred. The learned counsel have invited a division bench judgment, so where the learned judges have held. In the present case, the decree was passed on compromise. It was admitted that by compromise, the properties allotted to the share of each party were clearly specified and scheduled allotted to each and appended the compromise. Here, everything is specified. Then, therefore, no further inquiries are necessary. In such circumstances, the decree did not merely declare the right of the several parties interested in property, but also allotted the properties according to the respective share of each party. Therefore, it was not a preliminary, but it was a final decree in the suit. A compromise decree in the partition suit, specific personal parties in a final order. There being already a final decree, the only thing that remained to be done was engrossed in the stamp paper of Article 40 stamp paper. The decree to the engrossed of the stamp will bear the date and so and declare the position of the parties. Therefore, there is There is no time limit prescribed by the statute for engrossment of partition decree on stamp paper requisite value. In respect, no date was fixed by the court for the purpose. Therefore, mere engrossment of the stamp paper requisite value will not be is not para 11 year. In our opinion, the law has been correctly stated by the division bench Patna High Court. The learned counsel for the appellant also relied on special bench so and so decision. The principles of law laid down in the two decisions support the view taken by the division of the Patna High Court. We find ourselves in agreement with the view of the law taken by the oath Chief Justice in Madras High Court. The decree dated 13 to 78, being a decree affecting partition by meets and bounds, ought to have been engrossed on stamp paper. The deficiency stood supplied by the same being rewritten stamp paper so and so. The event is so and so valid. As much the decree partition of property by meets and bounds, wherever Sutra felt the share of the group 2 is Amritsar Singh and Amritsar, they were entitled to transfer of this. Here also it is very clear that it's not necessary to pass a plea in a particular, not necessary. It may, a court has a discretion, it may not be also. Now I come to your lordship, the question of law. Your lordship, I gave a judgment, your lordship, of the apex court order. That is, Hemavati, it is there, I think. Hemavati. This, I give the judge Hemavati and others versus on section 100 CPC. So, lordship, see, I take your lordship to page 6 here. Probably the page 6 here. Here, the jurisdiction of High Court to enter a second appeal is well known. It is a unique jurisdiction of the High Court where the High Court can entertain regular second purely on a substantial question of not even a question of law or a question of fact. It is a settled law that the first appellate court is a final court insofar as the question of fact are concerned, and it is only when substantial question of law would arise in a case that the High Court can enter a regular second appeal, and if at the stage of admission a substantial question law are discerned by the High Court, the same would have to be framed by and the appeal would be had to be admitted. It is only thereafter the parties have to be heard in substantial question law and the framed by High Court at the stage of admission. Your lordship, here it's very clear, your lordship. Then I take your lordship to page 8, your lordship. They have referred it. In this context, the law of practice followed while considering regulation has been reiterated by the court in so and so judgment is 2000 so and so. It is reiterated that section 100 jurisdiction of the High Court the entire second appeal is confined only to such appeal which involves substantial question of and does not confer jurisdiction High Court to interfere pure question of while extend jurisdiction under section 100. Then next, it is a matter of concern that scope of second appeal is also procedural aspect, and second appeal are often ignored by the admitting the second appeal which does not register a substantial admitting a without formatting substantial question of law, admitting a second by formatting a standard or mechanical question, such as whether on the facts and circumstances of the judgment the first appellate court calls for interference in the substantial law. This is very important. This cannot be solved. Failing to consider the formal relevant approach substantial law involves second appeal, rejecting second appeal on the ground that a case does not involve substantial question law, which does not involve fact involves substantial question law, reformulating the substantial question after conclusion of hearing or preparing the judgment, thereby denying opportunity to submission of so and so. Decided second appeal so and so representative. Then I come to C, the Municipal Corporation or Committee. A second appeal cannot be decided merely on equitable grounds, and it lies only on a substantial question law, which is something distinct from substantial question of fact. The court cannot enter a second unless a substantial question law is involved, as the second appeal does not lie on the ground of erroneous finding of this based on appreciation of relevant evidence. The existence of substantial question law is a condition present of the entire on failure to do so. The judgment cannot be maintained. The existence of substantial question law is sine qua non for exercise of jurisdiction section 100 CPC. It is obligation on the part of court further clear intent legislature not to intervene. In our view, the very decision of the High Court in hearing a second appeal is founded on the formulation of substantial question. The judgment of the High Court is rendered patently if the second appeal is heard on the judgment appeal against the reverse without formulating a substantial question. The second appellate court decision of the High Court on the second is not akin to appellate decision under section 96 of the code. There are two different things. It is restricted to such substantial question of law and may arise from the judgment and decree appeal against. As a matter of the second appeal is entertainable by the High Court only upon the substantial question law involved in a matter of formulating thereof. Section 100 of the code provides that the second appeal shall be heard on the question so formulated. It is however open to the High Court to reframe the substantial or frame substantial affairs on whole substantial involved at the time of hearing of second, but reversal of the judgment of decree passed by the appeal by a court of subject to exercise under section of the is impermissible without formulating substantial question law. In the instant case, the High Court has not yet admitted it is not in dispute. No substantial question law has been formulated, as it could not have been done if appeal had done. We say that our appeal section 100 is required to be admitted only on substantial question law. It cannot be formulated under so and so. The formulation is permitted character so and so. Then I come to in the circle impugn judgment impugn passed by regular as well as review petitioner. The matters even so. This is the party. Your Lordship, this is the thing. Now your Lordship, here your Lordship, so far a second substantial question was framed by the court. Your Lordship, when they framed the question, it is a prima facie opinion of the court. When the court formulates substantial question of law, it is a court by cursory view frames the question of law. Now, whether that substantial question law would be a substantial question law at the stage of final is a different thing. The court has empowered to find that the question of law which has been framed by this honorable court at the time of admission can be adjudicated, can be gone into by the learned judge while hearing the main matter as to by seeing the entire fact whether these are substantial question of law or not. This is very important. Here, your Lordship, in this case, according to my respective submission, the questions of the so frame are not questions of all facts of fact, question of facts here. Because if your Lordship will see a question of law frame, because at that point of time, order, if your Lordship will see that this judgment says whether my Lord has got a first page, beginning page, the order 5/2/2024, the order of this honorable. Whether the finding of the appellate court is perverse for non-consent exhibit F2, document and Jamabandi copy 90, as per which measuring sticker and the purchase by. These are question of fact, not a question of law at all. Perversity is not I have shown that there is no perversity. From the record, the appellate court has dealt with each and every issue. It may set aside, but they were like a question they have decided here. Whether the finding of the learned first appellate court that the suit land and the schedule land joint is perverse, how can it be perverse? It has been documents are saying that whether I've order 41 ruled it is my learned first district. So now these are according to me, these are not questions of law, Your Lordship, at all. Now I come to the second matter, Your Lordship. Second matter, Your Lordship, I raised an issue, Your Lordship, on the last occasion. If Your Lordship will see in this petition, my learned friend has raised this issue. Here, Your Lordship, my learned friend issued this question. He has framed 7 questions of law. That I did it. Now I take Your Lordship to CPC, Your Lordship. My Lord, I am taking the order 41, Your Lordship. No, 40, no. This is something else. memorandum. Yes, I'm on reference. And order, I'm not on order 41, rule 31. I'm on order 41, the form of appeal, Your Lordship. Rule 1 as a read from rule. What to accompany memorandum? Every appeal shall be prepared in the form of memorandum signed by the appellant or his peer. This is not necessary. Next is important, Your Lordship. Contents of memorandum. The memorandum shall forthwith concisely and under distinct heads the grounds and objection to the decree appeal from without any argument narrative. Such grounds shall be numbered consecutively. Where an appeal is against a decree for payment of money, appellate court within such time, appellate court may allow disposal. Grounds which may be taken in appeal. The appellant shall not accept the leave of the court, urge or heard any supportive ground or objection not set for the memorandum appeal. But the appellate court in deciding the appeal shall not confine the grounds objection, therefore, memorandum. So, Your Lordship, here there is no memorandum. Here is a question of law. History. This cannot be second memorandum. Second under this provision. This Your Lordship and this Your Lordship record my submission here. That is all. Your Lordship, this is I cannot have. Question is under this mandatory. This is a mandatory provision. It has not been done. The learned judge might have seen the question. You might have seen the whole thing, entire thing. But when I pointed out, Your Lordship should go see that.
No, grounds have been mentioned there.
No, correct. No, these are question of law. Yeah. Yes. Grounds for inviting substantial. The grounds for inviting substantial question. He has framed this. These are substantial. He has stated these are substantial question of law, Your Lord. That is his case. These are question of law.
Well, this provision is applicable when there is an appeal from original decree. We are not. This is not an appeal from the original decree. We file regular second appeal under section 100 on the substantial question of law. The heading is very clear. Order 41, appeals from original decree. This is not at all applicable in the regular second appeal. Second appeal is admitted under section 100. We file the appeal under section 100.
I felt Your Lordship, record. Then Your Lordship, I may come. So here in this matter, in this matter, they are banking on adverse possession, Your Lordship. Their claim is based on adverse possession. Defendant about 6 to 8, who has filed the second appeal, it is based on adverse possession, Your Lordship. Now, Your Lordship will see. Again, oral persuasive, those I need to repeat those arguments, Your Lordship. Then that 60 years that have oral partition. Here, if Your Lordship will see, adverse possession, they have not laid any evidence. No evidence has been laid on adverse possession that they are in adverse possession. No evidence has been laid as to how they have come in adverse possession to the thing. Because the records is saying the other way around. Then, Your Lordship, so far the counter claims also, this has not been adjudicated at all, Your Lordship. I told the issues has not been framed, it will not be adjudicated. So as a result, Your Lordship, so far I think this both the second appeal has liable to be dismissed, Your Lordship. There is no substantial question of law is not there, and this has to be rejected, Your Lordship.
So the judgment relied on by the learned counsel for the respondent, the first judgment regarding the judgment relied on by the learned counsel for the respondent are not relevant in the present case, because the first judgment relied on by the learned counsel regarding the fulfillment of requirement of Order 20 Rule 18, the lordship will find in the judgment there was a decree on compromise. When there was a decree on compromise, everyone has settled their own share.
Which judgment you are referring?
My lord, the learned counsel for the respondent
Right, just like
I have not got the citation.
uh,
No, I have not been
Like that.
supplied with the copy.
Is your lordship? Two 2003 10 STC 20200. Can I have given?
My lord, the 2003
10 STC.
NSCC,
No, renew review.
2003 NSCC, page 200.
Yes.
Here your lordship will find the decree was arrived at by of a compromise. When there is a compromise decree, I just heard when the learned counsel for the respondent was reading the judgment, when there is a compromise decree, the shares are already settled. So when there is no dispute regarding share, the court need not pass any preliminary decree. But when there is already a dispute regarding the share in the property, and there is a plea of adverse possession also, the shares are not specific. So who will determine the specific share of the property? It is the collector as per section 54 who will determine the share of the revenue paying state of the respective shareholders. And the report will be sent to the learned court, and accordingly a final decree will be drawn that the share has been given, specific share has been given. If we go to the decree passed by the learned past appellate court, there is no apportionment of share, there is no direction, no issuance of precept to the collector for dividing the shares among the shareholders. It is the requirement of law, Order 20, Rule 18. And the judgment relied on by the learned counsel for the respondent, it is on a different footing. The judgment is that the decree was arrived at by of a compromise. And the second judgment relied on by the learned counsel for the respondent regarding the requirement of substantial question of law, it should be question of fact, question of law. I have heard. This judgment, my lord, I have gone through the judgment. This judgment, here the High Court disposed of the second appeal without formulating any substantial question of law. Here the Supreme Court has laid down the law regarding the formulation of substantial question of law in an appeal filed under section 100. So this is the facts and circumstances of the judgment, and the facts of the judgment are different. This is not at all applicable to the present facts and circumstances of the case. Here the substantial question has law has been formulated by this honorable court, and it will be decided. May go in my favor or maybe against me. But the judgment has no relevance with the present case. There the issue was whether High Court could have disposed of the regular second appeal without formulating any substantial question of. No, the second judgment relied on by the learned counsel for the respondent.
I don't find any law without then why should I reject?
No, that will come during the course of hearing. There the Honorable High Court admitted the second appeal without formulating any substantial question of law. That issue was decided by the Honorable Supreme Court. That without formulating substantial question of law, a second appeal cannot be admitted and adjudicated. Here, rightly or wrongly, substantial question of law has been formulated. It will be up to this Honorable Court during the course of hearing to allow or not to allow. And regarding the plea of adverse position, they have taken a specific plea that, and there is no written statement filed against the counterclaim. There is an exhibit marked at Exhibit 1. In the record, there is no written statement on record. They have exhibited the written statement without signature. So whether that written statement can be taken into consideration for deciding the present dispute.
But
Trial court has not considered, but that plea perhaps was not raised during argument. And
in the document trial,
no, the written statement,
Para 21 type of.
the para 21, the observation of the learned trial court is regarding the written statement filed earlier. Due to oversight or overlapping, perhaps perhaps the mistake was committed. But on record, I have checked the record. There is no written statement against the counterclaim. I have checked the record. There is an exhibit marked as Exhibit 1 without
Page
signature.
51, you are correct.
Without signature.
Page 51, correct. Yes. Yes, category stated. 20.
This is the wrong observation your lordship may take into
Lordship
consideration.
challenge.
And another line of argument that there is perversity cannot be ground for formulating the substantial question of law in my humble submission may not be correct. The perversity, if it goes to the root of the case without considering the relevant evidence, that it can be a substantial question of law as held by, in the case of Santosh Hazari, your lordship is aware, 2001 3 SSC 179. Your lordship is well aware about the judgment, so I am applying a copy. Regarding the 1941 document, there is no finding by the learned past appellate court. Joint purchase is in the record of 1946. We are not denying that there is no joint purchase of 4 kathas of land. But regarding 3 kathas, 18 letters of land, this was purchased by the father of the defendant number 1, self-acquired property. And it is included within the 4 bighas of land. We are not saying the disputed property is 6 bighas. It is the observation of the court while perusing the record, the total land in the patta is 6 bighas. One Mr. Borua's name is also there in the patta, co-patta that. But the total land is 4 bighas. And we are saying that 3 kathas, 18 letters of land has been purchased by the father of the defendant number 1. And this finding was correctly recorded by the learned trial court. But while in appeal, so there is only one appeal, no court fee is filed, submitted for the counter claim appeal. So your lordship will consider only one appeal against the suit because they have valued the appeal at rupees 600, which is the value of the suit. Counter claim was never valued, no court fee was filed. So in the absence of any appeal against the counter claim, the finding may not be correct, arrived by the learned first appellate court.
The objections were never raised in the trial court.
No, I need not raise any objection. It is the requirement of law. Requirement of law objection can be taken at any stage. And regarding the 1941 document, the 3 kathas, 18 letters of land we have purchased, it is the self-acquired property of the father of the defendant number 1. There is no finding arrived at by the learned first appellate. Learned first appellate court has only decided the document of 1946, which we are also admitting that a 4 kathas of land was jointly purchased by Dihola and Moishar Gogoi and 2 of the brothers. There is no discussion. Regarding the plea of adverse possession, admitted fact, your lordship may not be proved, need not be proved, as per section 58 of the Evidence Act. They have admitted in their evidence, PW1, and say 60 years, they are not in possession of the land. They never claim the land.
If it was covered by
Well, there is a judgment of Honorable Supreme Court regarding the adverse possession against the co-sharer. If we can establish, because in 1995 we have taken a specific plea in our counterclaim. In the 1995 the dispute arose. We denied their right title interest over the land. After that, they did not file anything, any suit whatsoever for claiming their right title interest. It is for the first time in the year 2012 they have claimed the right title interest. And they have taken a plea in the plain, specific plea, that there was a mutual partition, which also denied by the PW1, their evidence that there was no such mutual partition being arrived at between the parties. We are not claiming that there was mutual partition. It was their pleading in the plain that there was a mutual understanding, and on the basis of which they are claiming that the different number 6 to 8 are the permissive possessors. No permission is necessary because we have been residing on the land since 1956. We have been able to prove before the honorable learned trial court by of adducing sufficient evidence the revenue receipts on 1978 onwards. So we have been able to prove the adverse possession, continuous possession, peaceful possession. It was no business.
Your Lordship, permit me to file written submission. Written submission.
But that's not possible.
Yes.
He has argued at length, my lord, cannot be necessary because only two issues I am raising: perversity, non-consideration 1941 document, and adverse possession. There is no written statement.
Which to violate why sort of like
Let him file also. He can file a bigger written submission.
hurt the appellant.
17 of 20.
Sir, for the arrest number 20. Put that argument on the keep it.
Much obliged.
I'm grateful to your Lord. Give me such a patient hearing.
Your Lordship, fix the matter for final hearing by 26, order 26. The matter has come up for order. The step is pending, but while hearing the hearing in part, Lordship indicated that the entire matter should be heard. So today is also coming for orders. Matter may come up for hearing on next Tuesday. Matter may be disposed of.
My lord, with all respect and regard, my lord, in disposal of this appeal, time still required. In the final disposal of this appeal, my lord, hearing both the sides, some time will require. In the meantime, my lord, they may be granted, my lord, subject to deposit of 50% of the digital amount, my lord. This is money degree, my lord. But my lord, my lord, at the same time, I have been facing actual hardship and difficulties, my lord, due to paucity of money.
After the other right, get art appellant better for final hearing on COVID.
Thank you. This month, my lord, is possible.
Transfer right.
Well, that is Thursday. Much obliged.
Okay.
Lord. Lord, the CRP is at the stage of final hearing, my lord. But unfortunately, the petitioner has expired. So we have filed two IAs, my lord, which your lordship was pleased to call for in the morning. So the IAs are before your lordship. One is under Order 22 Rule 9 and one is under Order 22 Rule 3. So the petitioner in the CRP is Muhammad Asad Ali, and he expired on 30th January 2025. And we, my name is Zed Mukit, my Mukit, my lord.
I am on behalf of P.K. Roy Chaudhary, my lord, for respond number 1 and 2. No, my
Here's at page number 9 of the I number, my lord. Yes, my lord. Rehanut Ali, Mohsin Ali, and Antara Aziza. Only one thing is there. This Rehanus Ali, he's the son, my lord. He's a specially able person. He's a specially able person. So mother will represent. Mother. Number 2, my
May it please your lordship. My lord, this is a regular first appeal preferred in respect of the title suit 86 of 2010. My lord, in this case, before proceeding on merits, the slight background of the facts. Both the item numbers 15 and 16, the regular first appeals preferred by the same appellants, were arrayed as the defendants in different title suit. Basically, the plaintiffs in both these title suits were husband and wife. They had purchased certain properties from the builder, which were under separate deed of agreement, and for which the consideration was paid separately, and therefore, my lord, separate judgment and orders decrees were passed in both these cases, and therefrom, these two connected regular first appeals have been filed. So, my lord, may kindly take up the first one, the RFA number 116 of 2017. That is 119 of 2007. That is item number 16. My lord, may I begin? My lord, in this case, the title suit 86 of 2010 was filed by respondent number 1 herein, Dr. Kishore. The respondent number 2 herein is one of former respondent number 2 is also one of the former directors of the appellant number 1 company, but he left, therefore is arrayed as a pro forma party. There is no relief sought against him. My lord, may come to the plain, my lord, at page 7. It starts from page 7. And at page 8, it is a suit for specific performance of the registered agreement for sale dated 8705-2007, dated 6/7/2007. My lord, may note that because there are two registered agreements for sale, this one in the present first appellant suit 86 of 2010 is the sale deed number 8705, dated 6/7/2007, between plaintiff Dr. Kishore Das and the defendant number 1. So, my lord, the plaintiff filed the suit for specific performance for the reliefs which my lord will find at page 30, specifically at page 35, starting from page 35. If I may read it, page 35. A decree of declaration in favor of the plaintiff and against the defendants, that the defendants are bound by the registered deed of agreement bearing number 8705 of 2007, dated 6 July 2007, executed by and between the plaintiff and defendant number 1. That's the company. A decree of declaration in favor of plaintiff and against the defendants for specific performance of the registered deed of agreement bearing so and so, dated 6/7/2007, in respect of the area more specifically described in Schedule A of the plain, thereby directing defendant numbers 1 and 2 to obtain the permission from the Guwahati Metropolitan Development Authority for conversion of the Schedule A area into a semi-finished area. So, therefore, second part is to convert this Schedule A area into semi-finished area, and thereafter execute registered deed of sale in favor of plaintiff in respect of Schedule A area as per the registered deed of agreement bearing number 8705 of 2007, dated 6/7/2007, within a time specified by Honorable Court, failing which the deed of sale be executed and registered according to provisions of Order 21, Rule 34. And permanent injunction, as stated in next page, page 37. So these are the three principal reliefs paid for in Title Suit 86 of 2010. declaratory as well as injunctory. The alternative reliefs, my lord will find at page 37 itself. That is the serial number 5. Plaintiff praying for decree of recovery of 40,30,124 from defendants on account of recovery of the principal amount along with interest as well as for special damages as stated in paragraph 28, 29 and 30 of the instant plain. The plaintiff prays for decree in favor of plaintiffs against defendants for general damages as deemed fit and proper, decree for costs and other relief. Now, my lord, we come to the schedule A. Let us ascertain, because there are two plots to the schedule A. It pertains to the ground floor of space of 1000 square feet under flat number 101 stroke A1 of the apartment known as Meghmallar Hill View, situated at Ganeshguri, Zatia, Guwahati, standing over plot of land measuring 1 bigger lectures, covered by so and so tag number, keep number so and so, village Zatia, Moza, Beltola town, Guwahati, district Assam. Now, my lord, this is therefore the ground floor of a 1000 square feet. They are seeking that to enforce the agreement for conveying that 1000 square feet of ground floor in the name of the plaintiff and execute registered sale deed, failing which the alternative reliefs for damages, special and general, would come into play. Now, one of the special damages, if my lord may simply go to page paragraphs 28, 29, which is at page page 31, 30, 32, 31, it starts from 31. Page 31. I may read from para 28, bottom paragraph, page 31 of the plain of the paper here. Internal para, page 25 of the plain. 31 as per the pagination of the internal page 25 of the plain. Para 28 below. Without prejudice to what has been stated herein above, plaintiff alternative states that if this honorable court is however not inclined to grant the relief of specific performance, plaintiff is entitled to recovery of the money already paid to defendants along with interest accrued thereof and for compensation for the injury caused to the plaintiff by defendants. As already stated herein above, ground floor space more specifically mentioned in Schedule A to the plan was an integral part of the setting up of doctor's clinic. The actions of the defendants in duping the plaintiff in respect of the Schedule A area have made the plans of the plaintiff to set up a doctor's clinic impossible, thereby causing huge financial losses to the plaintiff. The actions of the defendants amount to breach of contract for which the plaintiff is entitled to special damages as well as general damages. It is stated herein that the plaintiff, after realizing the fraud committed by defendants, had inquired with various real estate companies in respect to similar areas as mentioned in Schedule 8 and could come to learn that the present rate is around 1,850 per square feet. Plaintiff also had to suffer mental as well as physical agony on account of illegal actions. Further stated here that plaintiff had invested hard-earned money to set up doctor's clinic, and the illegal action of defendants have, apart from causing physical mental agony, have also caused great financial loss to the plaintiff respect of professional works. The plaintiff prays for special damages for an amount of rupees on the following counts. These are the 1, 2, 3. Next page are the special damages. Serial number 1, financial loss caused to plaintiff in respect of professional life on account of illegal action defendant, calculated at a rate of rupees 1 lakh per month from 1/10/2009 till date, comes to around 6,50,000. Loss caused to plaintiff both mental and physical account of illegal action of defendants, 10 lakhs. And loss caused to plaintiff on account of breach of contract, calculated in the following manner: the rate per square feet so and so for the ground floor area 1000, present rate, differential rate 920, therefore applying the differential rate 9,20,000, total claim coming up to 25,70,000 as special damage. Para 29. So, my lord, in this a brief synopsis of this, if para 28, first part is saying that because of the defendant's appellant here's actions, the doctor's clinic could not be set up. Therefore, he's claiming damages caused by the financial losses for breach of contract, mental and physical harassment and agony on these counts. Because, and on the basis that he had inquired with other real estate companies, inquiring what is the present market value of that 1,000 of the per square feet value of that 1,000 square feet of land in that particular area. Therefore, coming up to that table 25 lakh 70. In para 29, plaintiff further entitled to an amount of next page 33 of 12 lakhs paid to defendants as consideration for the Schedule A area. Plaintiff had taken 3 lakhs out of the 12 lakhs from the State Bank of India as loan at the rate of 10.75% per annum, and plaintiff as on date of filing of suit is still paying the installments for the loan. Furthermore, in respect to amount of 9 lakh, the plaintiff had taken loan from private persons at an interest of 12% per annum, still repaying that amount. Therefore, on this amount entitled to the following amount on account of interest and principal. Principal amount paid by plaintiff 12 lakhs, if interest paid charged by the State Bank of India coming out to 89,100, and interest charged by private persons coming up to 1,71,000. Total amount coming to 14,60,120. Thereby, the plaintiff arrives at a sum of recovery of 40,30,124 as stated in the alternative relief portion. Prayer number 5. Hello. This is the calculation of the special damages. Now, my lord may turn to initially that the agreement dated 8705, my lord, since it is a suit for specific performance, what is sought to be performed, we have to ascertain what exactly has been sought to be performed. My lord, we turn to page 70. This is the agreement to sale dated 8705. It starts from page 67. I'm not reading the. I'm going to turn to page 69. This is the recital of the actual recital of the. Whereas the first party company was formed with the objective to deal in real estates and housing schemes and is currently engaged in building apartment blocks for sale to prospective buyers on the plot of land, more particularly described in Schedule A, empowered to be utilized by the builder company by virtue of power of attorney executed, and whereas apartment building is under construction on the plots of land mentioned in Schedule A, after fulfilling the due formalities, said apartment to be known as Megmallar Hillview at Ganeshguri, Jatia, Guwahati, described in Schedule B. Whereas the second party applied to the first party for allotment of 1,000 square feet in the ground floor in the complex known as Megmallar Hillview, situated at Ganeshguri, Jatia, Guwahati, more specifically described in Schedule C. Whereas the second party purchaser agreed to purchase an ownership basis at Jatia having 1,000 square feet on the ground floor in the complex described above for a consideration of rupees 9,30,000 against cost of floor stroke roof, proportionate share of the land and construction charges including raw materials fully paid as described in Schedule D of this deed. Now, my lord, this is the power of attorney. My lord, we come to page 70, terms and conditions. It will be relevant. So the agreement is for allotment of 1,000 square feet in the ground floor in the complex known as the Megmallar Hillview apartment for a consideration of 9,30,000 as per this agreement. Now, next page, my lord, I will read from the beginning. Terms and conditions for the allotment of an apartment of Megmallar. The intending allottees is applied for allotment of an apartment with full knowledge and subject to all the laws, notifications, and rules applicable to be applicable to this area in general and group housing project in particular, which have been explained by the company and understood by him, her, them. The allottees have satisfied himself, herself about the interest and title of the company on land in which the said apartments are being constructed and has understood all limitations and obligations in respect thereof. Intending allottee agrees that there will be not any further investigation or objection by him, her, them in this respect. Now, clause 3 is important, my lord. The intending allottee has seen and accepted the plans, design specifications, as set out in the brochure and agrees that the company may make such variation, alteration, modification therein as it may in its sole discretion deem fit and proper, or as may be done by any competent authority, and the intending LOT thereby gives these are the consent to such variation, additions, alterations, and modification. Intending LOTs is also seen the specification information as to material to be used in construction of the building flat as set out in the brochure, which are also tentative, and the company may make such variation and modification therein as it may in its sole discretion deem fit and proper, or as may be done by the competent authority, and the intending LOT hereby gives this consent to such variation and modification. Now, clause number 4, my lord. Company shall have the right to effect suitable and necessary alterations in the layout plan of the building or block of buildings if and when found necessary, which alteration may involve all or any of the following changes, namely change in positions of the apartment, change in the number of apartment, or change in dimension, or change in area. To implement any or all of the above changes, supplementary agreement if necessary will be executed. If there is any increase, decrease in the areas, the rate per square feet, meter, and other changes will be applicable to change area at the same rate at which the apartment was booked. If for any reason the company is not in a position to allot the property applied for, the company shall refund the amount deposit with simple interest at the rate of 10% per annum. Because that is one of the contentious raised in that we cannot allot them the property as they had applied. Number 5, the intended LOT shall not be entitled to have the LOT name changed or substituted. My lord may come down to paragraph 6. The intending LOTs agrees that he, she, they shall pay the price of the apartment and other changes on the basis of the super area, covered area of his or her their apartment, pro rata share of the common areas, and converted cost of services like cost of lift where applicable of the building. The price of apartment shall, however, include such external works like underground septic tanks, soak pit, groundwater tanks, water supply system, boundary walls, gates, and limited site development work like filling and leveling of campus up to existing peripheral road level. All intending roads shall be gravel with stone dust finish. Clause 7. This is on the payment. The time of payment of installment is the essence of this agreement. It shall be incumbent on the intending LOTs to comply with terms of payment, other terms and conditions of sale. In case the installments are delayed, intending LOTs shall have to pay the interest on the amount due as follows. Up to 1 month delay from due date of outstanding amount, 12% per annum. 3 months delay from date of outstanding amount, 18% per annum. Even then, if the intending LOT fails to pay the installment interest, the LOT shall forgo the entire amount of registration money deposited by him, her, and the allotment shall stand cancelled, and they will be left with no lien on the flat apartment. Amount, if any, paid over and above the registration money shall be refunded to the intending LOT without any interest. Now, my lord, may come to clause 9, page 71. The company shall endeavor to give possession of the apartment flat to the intending LOTs within a period of 2 to 3 years from the date of execution of deed of agreement and on complete payment of the sale price and other charges due and payable up to date of possession of the apartment. In the event of his failure to take possession for any reason whatsoever, he shall be deemed to have taken possession of the portion of the apartment allotted to him. Therefore, my lord, this is one says the clause 3 says that they have seen the design plan specifications and they've accepted it. Any verification which is required to be made by the builder or by the authority, competent authority, they have consented to that if required in law. Then 6, that they shall pay the cost covered built-up area, super area, and also pro rata share of the common areas and the converted cost of services like cost of lift, which is separate from the price of the apartment. And clause 9, the possession shall be given to be endeavored within a period of 2 to 3 years from date of execution and on complete payment of the sale price. That is important. Clause 10 says, till such time as full payment of sale price and other charges dues remain unpaid, the intending LOT covenants with the company that he, she, they shall have no objection to company raising finance, loan, securities from within the financial institution, again receivables, for construction of apartment by creating mortgage on the land apartment. Now, my lord may turn to the next page. These are on maintenance. Clause number 13, page 72. The intending LOT shall pay as and when demanded by the company the stamp duty, registration charges, and all other incidental and legal expenses for executing a registration of the sale deed of the land in favor of the intending allottees, which shall be executed and got registered after receipt of the full sale price, and other dues, and after execution of the registered deed of conveyance. The intended purchaser will acquire right, title, interest of the flat apartment allotted to him or them, along with transferable and heritable right, and shall be owner over a proportionate share of the land according to proportionate super built-up area of the flat apartment, jointly with other purchasers of the flat apartment in the proposed complex. So again, my lord, price of the apartment is there, the lift charges, common area charges, then comes the stamp duty, registration charges, and other legal expenses. Those are additions to the price of the apartment. And it may come down to clause number 19 in the next page. The intending allottees agree that if as a result of any legislation, order, or rule, the company after allotment is unable to deliver possession to the intending allottee, the only responsibility and liability of the company will be to pay to the intending allottees the amount attributed to the said apartment that may have been received by the company at the time, without any interest or compensation of whatsoever nature, in the manner as may be decided by the company, same as aforesaid. Neither party shall have any right or claim against the other in relation to this agreement. So, my lord, this is where the change of law applies. Change of law clause. Again, my lord, this is a force of clause 22, force majeure clause, or anything. The intending allottee agrees that the sale of the apartment is subject to the force majeure clause, which entirely include delay on account of non-availability of steel or cement or other building or water supply, electric power, slowdown, strike, act of God, emergency action, or if non-delivery of possession is a result of any notice, order, rule, or notification of the government or any other public or competent authority, or for any reason beyond the control of the company, any of the aforesaid events, company shall be entitled to a reasonable extension of time for delivery of the possession of the said premises. The company, as a result of such contingency arising, reserves the right to alter or vary the terms and conditions of allotment, or if the circumstances beyond the control of the company or so warrant, the company may suspend the scheme for such a period as it may consider expedient, and no compensation of any nature whatever can be claimed by the allottee for the period of suspension of the scheme. In consequence of the company abandoning the scheme, the company's liability shall be limited to the extent of the amount paid by the intending allottee without interest or compensation whatsoever. So this is for cancellation. And next page, the intending clause 25, the intending allottee agrees to pay the total cost of area 9,30,000 as per the payment plan be enclosed. So, the schedule A. The schedule A, if my lord will recollect, that schedule A is the overall complex 1 bigha, 0 katha, 1.62 liters, covered by so and so dark. This is the schedule A. Schedule B is the apartment complex. This is 1 ground plus 5-story building, consists of 20 numbers 3-bedroom flats and 10 numbers 2-bedroom. Schedule C, with which we are concerned with, this is the allotment number 1,000 square feet open space on the ground floor under flat number 101 A1. And the schedule D is the payment schedule of 9,30,000. So therefore, my lord, on coming to the relief, the version of the plaintiff as stated in the plaint. Now we come, my lord, that since we have a brief idea of what is actually sought to be enforced, at page 7, the plaint starts, and therefore at paragraph 3, I'll be reading only the relevant averments, which are their principal contentions. Paragraph 3, as represented to the plaintiff, the defendant number 1 is a company engaged in business of real estate. The plaintiff and his wife, Dr. M.D. Mazumdar, who is a senior consultant gynecologist, being interested in opening up a doctor's chamber cum clinic, had approached the defendant number 3, who was then a director of the defendant number 1, for purchase of an area in the Megmallar Hillview apartment situated so and so. On 18/6/2006, the defendant number 3 informed the plaintiff and his wife that in the said Megmallar Hillview apartment, on which construction was going on in full swing, the defendants can provide a ground floor space measuring 1,000 square foot plus a frontage area of approximately 400 square feet and an area of 1,375 square feet in the first. It was further informed that for ground floor space of 1,000 square feet plus an area of approximately 400 square feet of frontage area, the first floor area of 1,375 square feet along with the registration cost shall come to rupees 33 lakh provided the plaintiff and his wife made advance payment of the said amount. It was mentioned that rupees 33 lakh has been quoted for the entire area stated above as an unit. Now, my lord, this averment in para 3 in my written statement, this is admitted. In my written statement at para 3, I have admitted, at page 41, I have admitted paragraph 3. So, for a ground floor space, my lord may recollect the date. This is 18/6/2006. As on date, offer is made for 1,000 square feet plus 400 square feet frontage area. On the first floor, a 1,375 square feet first floor flat for a total consideration of 33 lakhs, provided it is made advance payment of the said. So that allegation is admitted. Now, my lord, the reason why I'm saying this is, my lord, because this is the initial negotiation. Thereafter comes the agreement, which is in 2007. The plaintiff and his wife were thereafter taken to defendant number 2 by the defendant number 3 in order to finalize the deal. At the time of finalizing the deal, the defendant number 2 also stated that the price of the entire area, which includes a ground floor space of 1,000 square feet plus an area of approximately 400 square feet of frontage area, first floor area so and so, shall come to rupees 33 lakhs. So again, it is reiterated. It was, however, mentioned that the permission for construction of the ground floor space of 1,000 square feet, though have been applied for, have not been received from the Guwahati Metropolitan Development Authority. It was further informed that the permission was just a formality and the defendant number 2 assured that there was a 99% chance permission will be granted, and if by chance the state permission was not granted, the defendant number 3 promised the plaintiff a contiguous 2-bedroom apartment on the first floor along with 3-bedroom apartment to be booked in the name of wife of the plaintiff, would be given to the plaintiff at rupees 14,94,200. Hello, this is important. This I have denied in my written statement. So the two aspects to this. The earlier aspect, which is admitted, is the 33 lakhs together paid upfront for that 1,000 square feet plus 400 in the ground floor and 1,375 square feet in the first. Next aspect is permission for the construction of ground floor space have been applied for but not received from the GMDA. And that was a formality. And if that by that formality does not occur, I have apparently assured the plaintiff that a contiguous 2-bedroom apartment on the first floor along with the 3-bedroom apartment to be booked in the name of the wife of the plaintiff would be given to the plaintiff at rupees 14,94,000. Therefore, 9,30,000 for the ground floor space. That was one side. Now the stand is that further negotiations coming that if in case that construction permission by the GMDA is not given, I would allot a first floor contiguous. There is a 3-bedroom BHK flat to the wife in the other suite and contiguous 2 BHK, because you will recollect this is an apartment complex consisting of 23 BHK flats, 10 2 BHK flats. The structure is like this: 3 BHK on one side, 2 BHK on the other side of the state. So that is the assertion that they have made, which I have denied, and this will come in later. Again, this is prior to the agreement, sale agreement. Paragraph 5 is important. The basic idea behind the purchase of the 1000 square feet of ground floor along with the frontage area of approximately 400 square feet and the 1375 square feet in the first floor, which corresponds to the 3-bedroom flat which was informed to the defendant number 2 entry on 18/6/2006, was that the plaintiff and his wife would open up a doctor's clinic wherein the ground floor area of 1000 square feet would be used as doctor's chamber and a portion of the 3-bedroom flat measuring 1375 square feet would be used as the patient's waiting. So, my lord, the first incongruity or contradiction that comes around here is that there is no use assigned to the 400 square foot frontage area. They have outlined the plans for the 1000 square foot as the doctor's chamber and that portion of the 3-bedroom flat directly above as the patient's waiting room. Both would essentially be converted into the commercial establishment of the plaintiff. But there is no mention of the 400 square feet frontage area, what it purpose it would serve. This will come into handy later on. So the plaintiff and his wife readily, next paragraph, my lord, agreed to the payment of said amount of 33 lakh for the entire area, which included the ground floor space of 1000 square feet plus area of approximately 400 square feet of frontage and the first floor area of 1375 square feet, which corresponds to a 3-bedroom flat along with registration. The wife of the plaintiff deposits the amount of 2 lakhs on 23/6/2006. Plaintiff paid an amount of rupees 2 lakh. The said amounts were duly acknowledged by the defendant number 1 on 12/2/2007. Another amount of rupees 4 lakh was paid by the plaintiff and his wife, which was also duly acknowledged by defendant number 1. Now, my lord, paragraph 7. On 22 June 2007, both the plaintiff and his wife were issued respective allotment letter. In the said allotment letter issued to the plaintiff, it was shown that the defendant number 1 had allotted an apartment flat bearing serial number 01 GR under construction project, Egmala Hilbis, Rejotia, Kalipara. The total cost of the said 1000 square foot was shown at rupees 9,30,000. It was further mentioned in the said allotment letter, total cost mentioned in the allotment letter does not include cost of extra work other than specification, laid down, registration, etc. In a similar manner, allotment letter was issued in favor of the wife of the plaintiff, where it was showed that apartment flat bearing serial number so and so 101 A1 was allotted to the plaintiff's wife for a total cost of 13,50,000. From the aforementioned amounts, it transpires the defendant number 1 was charging 22,80,000 for the 1000 square feet of ground floor space, and rest of the amount was of 10,20,000 was charged by for the purpose of registration, frontage area, etc. So, my lord, this is his assumption. I have denied this. That in my written statement, I have stated clearly. My lord, will come up to this is paragraph 7. I have stated clearly that in total, I have received 16 lakhs from the plaintiff and remaining 14 lakhs was paid on account of extra renovation work, modification work done by the plaintiffs themselves in the presence of the site engineer. Because my lordship will kindly note, their plan is laid out by their own admission that we do not need a flat, we want a doctor's chamber and a patient waiting room. And later on, subsequently, they have also in their letter, they have stated that they have demolished, modified, altered certain plans of the first floor apartment so as to make it a part, both the units to made a part, a same unit virtually. The total, even if admitted amount on record as per my submission is 30 lakhs, even considering that I have taken the entire. First point raised is the entire amount of 33 lakhs which they have claimed to have agreed to has not been paid till date. There is no discharge or showing of willingness to perform because till date they have only paid part of the payment. And therefore, and they are saying that even that part is paid only for modification. A part thereof is 14 lakhs is paid for modification of the premises. That is the point I raised in my written statement. I'll be going there.
The copy that for 5.
My lord, paragraph number 5 is paragraph number 6. Paragraph number 6 total. At page 43. I'll be coming there too. I'll be reading that part, but I'm just mentioning for your lordship. My lord, may I make a suggestion? My lord, may keep this part. But I have to leave for Itanagar today. I have a matter today. I'll be driving to Itanagar, so it will be difficult for me to continue beyond a particular time. And it will be late to reach there. If my lord may fix a date, we'll continue.
That in the month of August.
Let it be third week of
Third week.
September.
Third.
The third week.
31st the matter.
18.
Yes,
Yes, same order. Same order.
Will it take after